Happy Thursday. It's time for Coffee and Cursey Words. We have a court hearing that we're covering today in the Idaho murder case. I have coffee. There are 8 new Girardi lawsuits and a bunch of other stories. I was pulling court documents because I saw something else that I hadn't seen in the Girardi case right at the last minute that I haven't seen reported on yet because the auctioneer's report is in on who bought the scandal earrings. I haven't even had a chance to open it, but I was like furiously pacering this morning after I did an interview with NPR. It's been such a busy couple of days, and I will tell you more about that in Q&A because some of you were like, can we get to this hearing and talk about it? We're going to do a little break from structure today. Normally we do Q&A all at the end, but we're going to talk about the Idaho case and then answer all of the questions with regard to that case. And then we will go into, if we have time, the Girardi stuff. I'm going to make time. Who are we kidding? Emily, clear the schedule. We have lots of law to talk about today. We really do. Let me know where you're coming in from. We have a few housekeeping items just to talk about real quick at the top of the show. And then I will pull up this court hearing. As a reminder, the Idaho courts are allowing a pool camera in the courtroom. So there is a court feed in the courtroom, but it is not streamed. So it is recorded and then it is allowed to be aired after the court hearing. So this is a actual look at inside of court, but it is not live and contemporaneous like these things are happening in this particular time zone. But time is all a construct anyway, so whatever. We're going to look at it together and we're going to go through it. Yes, the hair is still done from yesterday. I'll talk a little bit about the things that I've been up to in a minute because the law nerds like to know. The members know, but the law nerds like to know. So we've got some cold weather coming in here to Middle Tennessee too. Good to see y'all getting in. You know what? Let's roll the intro. We will be zhuzhing it, don't you worry. But it's time to get in. We have so much to do today. Hey there, I'm Emily D. Baker, everyone's favorite legal analyst, breaking down the legal side of the pop culture stories we can't stop talking about. I've been a licensed attorney for over 17 years. I'm a big fan of the Cursey Words. And remember, this is not legal advice. Okay, it's time. Let's just get into it. We do have a lot to talk about today. But first, I want to give an update on my friend Rick Hoeg, who is recovering from a stroke that he suffered on December 30th. Rick has been on this channel. I have been on his channel. I have talked about his content quite a lot because I love hangouts and headlines and the way he breaks down media. And we really do get along quite well. It's been nice to be in touch with his wife and hear how well he is recovering. And I am tremendously proud of him. I know his wife is tremendously proud of him. And he is absolutely working and has moved into his kind of first rehab facility after the stroke to keep moving. It was funny because she has shared some stories about Rick and is sharing those over on the community tab as well, but has put together a GoFundMe that I want to share with you. And again, this is for those of you that have asked. I will be donating to the GoFundMe. I have not had a chance yet. This went live yesterday. I was out of pocket most of the day yesterday. I will be sharing this across socials. Again, for those of you that want to support and can support, Rick is the breadwinner in his family. He is a young man and he is going to be rebuilding his life after this stroke, but that is also going to include medical expenses that are unforeseen, time off of work. Just from my own personal experience, when my oldest was in the NICU, the bills that we received, and insurance covered a lot of it, but it was hundreds and hundreds and hundreds of thousands of dollars for that hospital stay. So for those of you that don't live in the US and are just like, hospital, yes, it can be insane. And hospital bills in the US, I think, are one of the leading causes of personal financial trouble and bankruptcies. It's really, really kind of wild. So I've seen, and had seen, not on this channel because y'all are law nerds and you would never, but I had seen on other channels being like, but Hoeg's a lawyer. Hoeg's a sole practitioner. So if Hoeg is not working, Hoeg is not earning income. And that is a difficult thing about law. Most lawyers do not make the kind of income that a lawyer like Tom Girardi makes. Oh, wait. Tom Girardi doesn't make the kind of income that a lawyer like Tom Girardi makes. So being able to support, I think, is a a wonderful thing if you are able to, and that is something you want to do. So I am going to share it with all of you. The mods have the link, and the link will be in the description as well. I will be sharing. It's incredible to see that they're at $53,000 that is going to go towards medical plans, going to go towards making sure that he has a home that works for him when he comes home, and all of the other things. So they have shared quite a lot of information about it, about him undergoing brain surgery. I think that is new information to the wider public. Things shared from Hoeg's sister and Hoeg's wife about his recovery and the potential expenses in that. It is wild to me that when you suffer a medical emergency in the US, that it can absolutely be devastating. So, and financially devastating as well. So we're all rooting for Rick, and I think giving his wife the peace of mind that the community is here not just to support him in a financial way, but also to help support his channel. And that's one of the things I've asked a lot of you to do. If you can't physically donate or financially donate, I completely understand, but you can go subscribe to his YouTube channel, watch videos you haven't seen yet, catch up on a whole season of Lawyers and Dragons. It helps keep the YouTube algorithm from being like, we don't know her, she doesn't go here. And if you watch through the ads, it helps support the family just by you watching. So there are two options there to support. And I'm very, very encouraged by what's been shared about Hoeg's recovery, and truly heartbroken that he has to walk through this. Recovering from unexpected medical has rocked my family more than once, and I get it, and I feel for them. But I also know that if anyone is going to come back, Rick Hoeg, it's going to be Rick Hoeg. He's going to be like, we're from Michigan. We've got this. Like, what are you talking about? He's like, I went to one of the toughest law schools in the country. A stroke is nothing. We've got all of this handled. And so I love that. So for those of you that are like, look, monetary donations are not it. Your time as a donation on the YouTube channel is also hugely appreciated. So thank you. Lucinda said, I have premium, so I don't get ads. Does it still help? Yes. YouTube channels do get a percentage of YouTube premium. So if you watch a video on YouTube premium, the creator does get a percentage of it. And actually in our analytics, it shows us what percentage of income we get from YouTube premium, what we get from memberships, and what we get from things like super chats, and then super thanks, and then what we get from others. The GoFundMe, of course, YouTube does not take a cut of, but anything that you can do is helpful, even just the support to keep his channel alive and well in the minds of YouTube, which is a huge thing. It's just a huge thing. YouTube will just be like, hey, you haven't posted in a while, and that can be really stressful too, and that takes the stress away. What about ad blockers? No, if ad blockers are on, the creator does not get the support. So thank you to all of you. I very, very, very much appreciate it, and I know that the Hoeg family does as well. So let us go to the first story from today. We are going to talk about this Idaho hearing, but I wanted to just kind of jump to the end result because I know that you are going to have, oh, we binged. For those of you new here, some of you, this might be your first bing. We binged. Where did we bing? Where are we binging? At 678. Well, thanks y'all for liking and subscribing. I didn't even have to say anything. I appreciate it. We binged. Look at us. I think it might be our first on-air bing of 2023. So for those of you that have not watched me live a lot, sometimes you don't know what happens when we bing. So here we go. Oh, it binged. Move your head. Ah! We binged. What does that mean? This thing actually makes a noise, the sub counter. The sub counter came into play when the channel was growing towards 100K, when we had a countdown to whether or not I was going to dye my hair. I know. I'm not going to tell anyone that this is not my natural hair color and hasn't been my hair color my whole life. I'm just going to rewrite history, but it's not. We dyed it at 100K, and we were kind of counting up to 100K, and then I connected the lights to it because I thought it would be funny. And then it happened all the time during Dep V Heard. It was just wild. But the run up, I never thought I would have a YouTube channel that would have 100,000. I started talking about law because I'm a giant nerd, and I started talking about pop culture because I love pop culture and I'm a giant nerd. And my husband was like, what happens when you run out of pop culture things to talk about? Are you sure you want to narrow down what you talk about that much? And I'm like, yes. So when we hit 100K, I was like, I never thought that the channel would be here. And I have felt that way every single time this channel has grown. I'm like, I didn't think this would be me. I have a microphone and a law degree, and I like to talk about the stuff that we talk about. So it just blows me away. So my husband and I sat down because we saw that the channel was getting close to 100K. And so that clip is from the stream of the channel hitting 100K. I still can't believe it. I still can't believe it. So now we're just like, okay, let's do it. Christine D asked, could you and other lawyer friends do a live stream on Rick's channel? It can be difficult for the algorithm if people start picking up, which is why I always suggest there's a whole back catalog and tons of great content on Rick's channel. So I always suggest go watch it. And I think me saying, all right, let's go do this. Let's go do this is the most helpful. Camille said, you have a mic. Oh, I do. I also have a soundboard. I have purple hair, a law degree, and a soundboard, and a love for pop culture.
So we've got it all together over here.
Which is great. So there will never be a stop to pop culture lawsuits. Exactly. And that's what it is. Let's see. 700K next. Absolutely. We're coming for it. Rachel Mills said, went to the Britney Spears court hearing yesterday and it was spicy. I haven't seen a ton of reporting on it. We will be covering the latest documents regarding sanctions and what have you. I am very, and a screaming goat. Yes. I'm very excited to see. So if you put that anywhere or if you reported it anywhere, Rachel, will you shoot me an email so I can pull up your coverage and share it? Also, yes, we have a screaming goat. And apparently a yodeling pickle is on the way, so it's great. Is it possible to run out of pop culture to talk about? I don't think it is. Yesterday I was recording something that will be aired on your televisions at a later time, and when I can tell you what that is, I will tell you what that is and where to find it. But the producer and I were chatting and she's like, no, I love it. I love that you talk about pop culture. She's like, Barbara Walters said something along the lines of, show me a person who doesn't like gossip and I'll show you a person that's not interested in people. And that's kind of what it is, though I don't consider pop culture gossip. It is talking about other people. And we're all fascinated in other people's lives and stories and details. We're really all nosy. We're nosy. And that's why we want to see what's going on in this court hearing today. So we're going to talk about this court hearing, but I do have to say we are in a very fortunate place today because we have a stream sponsor. So I'm going to share the stream sponsor. I take sponsorships of things that I like. And when this sponsor reached out to me, I yelped. I was like, no way, really? And they have sponsored the channel before, so you might be familiar, but I want to know your thoughts because I will be in the chat seeing what you have to think as we thank today's stream sponsor. Y'all know I'm not one to brag a lot on the internet, but I have to brag, and today's sponsor gives me the perfect opportunity. So I was laying in bed playing Two Dots. It's such a fun game. It's soothing, the little sounds when you tap your dots. It's a beautiful design, and though it's a simple game, it can be a challenging game, which is where the brag comes in, because I finally beat level 107. The amount of time I have been stuck at level 107, but I got determined not to use any of the boosts or power-ups that you get within the game and trying to organically beat level 107. And when I finally did it, this is literally me on my phone in bed playing Two Dots and going, ah! And Dr. B is like, what happened? I'm like, I finally beat level 107. It was such a rewarding experience, and it's a game that I do like to play when I unwind. It's a really fun, casual game that's free to download on your iOS or Android device. There's a reason why this game has over 115 million downloads, and there's little side games like Scavenger Hunt and Treasure Hunt that pop in weekly that you can choose to play or not, so there's always something new and fresh to do. So if you want to check it out for yourself, just go ahead and download the game. I've got the link in the description down below, and let me know how you enjoy it for yourself. Okay, I am still stuck on this week's Scavenger Hunt. Some of them are hard to find. Oh, we should probably get back to the stream. Emily, get back to the stream. Okay, we'll get back to the stream. I promise. Law nerds, y'all are Two Dots fucking professional up in here. Look at you. I'm on level 109. You guys are bomb at two dots. I'm going to have to do this more. I am now like, there's a level 2000. Like, look at y'all. Look at y'all. Look at y'all. Oh my God. Law nerds. So if you haven't tried it, a lot of you clearly already have. If you haven't tried it, go ahead and hit the link in the description. Thank you to Two Dots for sponsoring. It's just so much fun. So I was playing it while I was away on the cruise, though you don't get the daily boosts when you're offline. You can still play when you're offline. So anyway, we should get to today's court hearing. I wanted, again, before we swoop into more difficult topics and start talking about literal, quadruple homicide, I wanted to talk about the lighter thing, which is after today, I might be sitting in the bathtub playing Two Dots. Yes, I play casual games in the bathtub. I do that. Does that make me weird? I mean, maybe other people do too, but it's me. All right, law nerds, let's pull this up. I mean, we are going to the feed from WFLA. If any of you watch this coverage on WFLA, you will know that incredible lawyer Peter Tragos, will be on with WFLA later today. So JB, who is such a great news personality because he has like news vibes, but he also has streamer vibes. So I feel like I know him. I don't, but JB was sharing that Peter Tragos will be on later today at WFLA. I'm sure lawyer, will be sharing it out. So you'll get his takes there and you'll be able to, see him and JB talk about it. He'll be in studio. He's a Florida attorney. So I think it'll be great. I'm really excited to see what Peter has to say, and I will be watching that later today. One of the things I love about the lawyers I've gotten connected with in this space is that I genuinely feel, and if it's me being naive, don't tell me because I don't want to know, but I genuinely feel excited to watch the other lawyers in this space showing up on your local news, showing up on TV, showing up at bar association meetings, talking about this stuff, and really becoming the next wave of legal analysts. And I'm so proud watching people I know just give incredible insights and commentary, because every lawyer has a different take. And I think the more conversation, the better. And I just love seeing it. So you guys go over there so that WFLA knows how much you love lawyer, because that's one of the things that the news media looks at is not just the bump in views, but the bump in comments and support. It actually does matter, and they will keep bringing someone back. So I really, really love this, and I am excited that he will be covering it later. I like the way WFLA does things. I don't find them to be hyper sensationalistic and clickbaity. I do like the way they cover breaking news with news, news coverage. Like, this is what's happening. This is what we know. This is what we don't know. And I appreciate it. Thank you for, holy shit, the news being, hey, this happened. We don't know about this. We have questions about that. Fucking wild. News reporting, just telling you what's happening in the world. Weird. All right, let's make sure we've got audio on this turned. No, I sure didn't. Turned up, and that it's all in the right place so we can hear the court hearing. You guys, I know, and the mods will let me know how sound is. At the very beginning of this hearing, we did not have sound, so the sound will come in a minute. I have pushed play. I do have to make an observation. I worked in courts for a very long time. I worked in courts in law school. I went to courts when I was an undergrad. I worked obviously as a district attorney in court every single day. This sign is of utmost importance to a courtroom. Look, do not fuck with the court thermostat. The clerk will take you out. Your cases will get set last in the day, and they'll be like, you need to be here right at 8. And then your case won't get heard till 10, because this is a very big deal. Do not mess with people in the courtroom. The court clerk, do not touch it. So this is one of those things that is just so real about a state level courthouse, is do not come in here and touch the thermostat. I love it so much. It's the first thing I noticed when I pulled this up today because of the camera angle, and it was just so real. It was just so real to me. So have you worked in that work environment? I'm sure you have. I'm sure you've worked in that environment. Chelsea said, you think you should be scared of the judge? You should be scared of the clerk. Yes. Whether it's the clerk or the judicial assistant, The people that you interact with in court that interact with the judge are the ones you need to know, because they are the ones that will go to the judge and talk mad shit about you if you do not act right in court. If you do not treat the court clerk with respect, the judge will absolutely know it. And the judge and their court staff are a team. They generally get along very well. And if you disrespect someone on the team, the court will not be pleased with you. So for all new lawyers, it doesn't matter if you're the lawyer, the court clerk is the boss of everything. And if you treat the court clerk just with humanity and kindness, isn't it wild that that has to be said? With humanity and kindness, it will go a very, very long way. A very long way. Things like if they notice a mistake, they will call you and say, hey, by the way, you're missing a couple pages here. Do you want to just shoot those over to me? I'll get it taken care of. As opposed to going to the court and being like, this motion's incomplete, set it out for 6 months. All right, let's keep going. All right, we heard a throat cleared. I want to give you the whole court hearing, so I'm giving you the whole court hearing. I will talk over it some. It looks like they're coming out from the back. If this is a jail location that is connected, then this is someone coming out of the connected jail location. He is casually walking in, unshackled. It doesn't appear by his gait to me that his legs or arms are shackled. I don't think there would be a reason to do so. This might be the procedure of the courthouse, but also you've got multiple bailiffs here. So, and we will continue on. So they're in court. Nobody is talking. The judge has obviously just come out because everybody stood up. So this is the defense attorney, this is the district attorney, this is another district attorney, and then you've got the officers in the courtroom and somebody sitting right behind the defendant is probably another defense attorney. This bailiff's here where he can eyes on, and then there's another bailiff off to the side. It's a pretty small courtroom.
Right, good morning. We are on the record.
This court is above the jail. Yeah, so this is an easy movement for them.
CR 29222805. This is State of Idaho versus
We love
Bryan
WFLA.
Kohberger. Mr. Kohberger is in custody. He is appearing here in court with his attorneys, Ms. Taylor, Mr. Logston, Mr. Thompson, Ms. Jennings appearing on behalf of the state. This is the time set in the matter for the preliminary hearing status conference. So I am going to inquire of counsel. Ms. Taylor, what's the status at this time?
Thank you, Your Honor. We are going to ask the court to set preliminary hearing out into June. We would request the 3rd or 4th week of June and probably 4 or 5 days for preliminary hearing. Mr. Kohberger understands his right to a timely preliminary hearing.
4 or 5 days.
He's willing to waive the timeliness to allow us time to obtain discovery in this case.
The defense attorney said something really interesting. We are waiving speedy trial. We are waiving speedy preliminary hearing. They have a right to have preliminary hearing within 14 days, and we are waiving that until June for 4 or 5 days. But what the defense attorney just said was, we need time to obtain discovery, but this also gives time for the prosecution to finish testing this defendant's DNA against the knife sheath. So it also gives investigators and prosecutors time to continue getting ready their case and to get more evidence. So look, this is more common than a case going to trial like the Darrell Brooks case. And of course, he was representing himself, so he had nothing really more to ask for. But with Darrell Brooks, that case was concluded inside a year of the massacre happening. And that was unusually fast for a case with so many involved. It is more common, and I said it the last time, that we would more likely see this case going out into 2024 if it goes to trial. I'm not surprised that we are seeing a preliminary hearing set out 6 months. It's going to be frustrating. Yes, we will talk about his face. I don't know what's going on with his face. Could he be shaving in custody? Yes, they are supervised when they're doing that. So who knows? I mean, it's really, really hard. It didn't seem that he had marks on his face at the last court hearing. We can always pull that up, but he might have tried to shave in custody, and that might not have gone well. But I'm not going to speculate too much. I see a lot in the chat asking about it because we don't know. And there's a gag order, so his defense attorney can't even come out and say it's from shaving. Please, internet, stop asking, because there's a gag order in this case. So This wasn't there last week. We don't know if he's housed isolated. I would absolutely look at Chanley Painter and Court TV probably have asked someone about that, but yes, razors in jail are definitely not going to be sharp. Let's see if I can turn this court hearing up a little bit. Every time this defense attorney stands up, she's away from the microphone because that's not her primary concern and gets quieter. So let me turn this up just a little bit. Let's just amplify it a little bit more. And if stuff gets loud, I can always gain it down. All right, let us continue.
And Mr. Thompson, are you in agreement with that?
The state has no objection to that, Your Honor. And Ms. Taylor reached out to us by email yesterday with her proposal. On reflection, the state's calendar would be better in the month of July, but we will make the end of June work if that's the court's preference. And I haven't had a chance to talk.
So what we know is that the defense attorney gave the prosecutors a head up. Hey, I'm going to be asking for the preliminary hearing to go out till June, which means they are at least working collegially together, which there's no reason they shouldn't be, to exchange discovery and set dates. And when the defense asks for something like that in a case that is this large and there's this much focus on, of course the DA is not going to say, no, go to preliminary hearing faster. They're like, thank you, let us finish the DNA and all the other work that we need to do. And it gives the defense time to start building their defense as well. So.
Ms. Taylor about that. I'm sorry, I know that's last minute.
That's okay. The court's calendar is going to be better towards the end of June, early July. So would that work, Ms. Taylor, for your scheduling on your other matters?
Your Honor, yes, if we take that fourth week in June, that's actually best.
90% of court is scheduling shit for another time. It really feels like it.
So, Mr. Kohberger, I need to speak to you for a moment then. Sir, you do understand, and Ms. Taylor has represented here, that she's advised you of your right to have, or fully discussed with you, the right.
The court is going to do the waiver. You have a absolute right to speedy preliminary hearing, speedy trial. So the court's going to go through all of those waivers. Yes, this defense attorney looks like Shannon Bedore to me as well. Like I can't get it out of my brain either. Do you think the victims' families were there? I'm sure we'll hear from the reporters that were in court if they were. I saw a little bit of clips of people walking in. It's very possible. So, let's see. Oh, excuse me. I refuse to believe that all courtrooms don't look how they do on Law and Order. I need dark wood banisters. I know. They don't. A lot of them just look like this. Not all of them are fancy.
Right that you have, which is to have your preliminary hearing within 14 days of the date that you initially appeared before this court. As you recall, when I advised you of your rights, that hearing is a probable cause hearing where the state has to establish that more likely than not, these felony offenses were committed and you were the one that committed the felony offenses. If you waive your right to a speedy preliminary hearing, it does not mean that you're giving up your right to have a preliminary hearing. It simply means that you would not be able to come back and challenge that the state did not present probable cause within 14 days. Do you understand?
Yes.
Have you had enough time to speak with Ms. Taylor about your decision to waive your right to a speedy preliminary hearing?
Yes.
Do you need any additional time to do so?
No.
Then I will ask at this time, as to the 5 counts, felony counts that were charged in the criminal complaint that was filed on December 29th of 2022, are you waiving your right to a speedy preliminary hearing and agreeing that that hearing can be held outside the 14-day period?
Yes.
And Ms. Taylor, do you concur with his waiver?
I do, Your Honor, thank you.
I will find your waiver of speedy preliminary hearing is knowing, intelligently, voluntarily entered here in open court with the assistance of counsel. We will go ahead and set the matter for preliminary hearing.
It's waived. And then the court's looking at the date. So I will get to questions right after this on this. So I think this is likely shaving as well. So who knows? I wonder if there will be an expert battle over DNA. Maybe not a preliminary hearing, but possibly when it gets to trial. We'll see. The prelim should give us a lot of information.
Monday,
The court's picking
June
the date.
26th at 9:00 a.m. And I will go ahead and reserve the week, so June 26th to June 30th, in the event that we need all 5 days for presentation of evidence.
So the prosecution
And
is,
just so council knows,
The court has
it will
set
begin
5
at
full
9
days.
a.m. each of those days.
starting
Is
at
there
9
anything
a.m.
further to address at this time in the case, Mr. Thompson
Not from the state's perspective, Your Honor.
That was loud.
or Ms. Taylor?
No, Your Honor. Thank you.
Okay. Mr. Kohberger, then you will be remanded into custody on your same no bail at this point in time, pending further proceedings. Again, we'll send notice out to council, and we will be in recess for this morning.
Thank you, Your Honor.
Thank you.
So that is not an atypical hearing. Very quick setting. The defense attorneys are following him back. They will probably have an opportunity to talk with him. He's already been brought to court. So that is not an atypical hearing. Bryan Entin just tweeted that the sheriff confirmed it was shaving. How did the sheriff confirm that? There's a gag order. That is an extra. Maybe it's not specifically within the gag order, and it's like, no, the public is going to lose their minds. I'm going to go look at Twitter real quick and see, and just pull up the tweet, because it's interesting. I think, again, this is the hard thing with a gag order. It's because there are these little moments of oddness, like, oh, did something happen in custody? Is this from the crime? Is this or this or that? And I'm like, we don't know. It's probably the simplest explanation is probably the one. And I really do appreciate Bryan Entin's coverage, and I cover him. And then I also, or follow him. I also follow Chanley Painter. Both of them are reporting live and in court. And those are sources that will give you the information and will give it fast. If there is ever a correction, they will make the correction. Excuse me. And I appreciate that about both of them. Because I'm not going to say nobody ever makes mistakes. When breaking news is being reported, mistakes can happen, but I've always seen them correct it. Sheriff says the cuts are from shaving this morning. I was in the third row and I did not notice the scratches on Bryan Kohberger's face in court today, but zooming in on the courtroom video, they are visible. Trying to find out more, going to be hard with the gag order. Yep. It's one of those things where there is probably a simple explanation, and it might have appeared more visible on TV because of white balancing than other things. So the defendant is staying on. What we learned from the hearing, before we get back into the defendant's face, the defendant is staying on no bail. So he's staying in custody. If there is a bail hearing, the defense can ask for there to be a bail hearing between now and the preliminary hearing. We might not see, just let it sink in, we might not see a hearing on this case until June, when the preliminary hearing is set. There is not much else that needs to be done unless something happens. He needs to be moved custodially, and the judge needs to do that on the record. They have a discovery issue that the judge needs to handle on the record. All of those types of things can warrant a hearing in court. But right now, the next court date is set in June, and that is for preliminary hearing. What's a preliminary hearing? The preliminary hearing is the first hearing for probable cause. Is this person likely to be the person that did the thing? Can we keep them in custody to trial? Is there enough evidence to hold them over to trial? And that is, not everyone does preliminary hearings. Sometimes you will see people do grand juries, and a grand jury does not have a defense attorney present. The evidence doesn't get probed in the same way, but you do bind someone over on a grand jury verdict. This is going to go to preliminary hearing. The judge is the fact finder at a preliminary hearing. The judge determines if it is more likely than not that the person in custody, Bryan Kohberger, is the person who committed these murders and can stand trial. It's not a finding of guilt. It is just a finding of there's enough evidence to hold you here and then go to court. Do we often see the defense put on much of a defense at preliminary hearing, an affirmative defense? Not often. Normally you get vigorous cross-examination, but not a actual defense, not defense witnesses. They don't need to tip their hand. Preliminary hearings are normally held over. Will this judge be the judge that hears the preliminary hearing? Most likely. But once the preliminary hearing is done, this case will move into a different court and then a different level of judge. So after preliminary hearing, it will move on to a different judge from there. And that won't happen, of course, till after the prelims. So preliminary hearing is a probable cause determination. Who will testify at preliminary hearing? Police officers, experts, and possibly, not necessarily, but possibly live witnesses as well, like the roommate who we talked about in yesterday's Emily Show podcast episode DM. If I'm the prosecutor, do I want to call that live witness during preliminary hearing? Given everything that I know now, which is what you know, what I know is what you know, you've heard me talk about it, we've all covered it together. I might not. The DA at the probable cause at the preliminary hearing doesn't have to justify the way they tied this case together. And if you get the DNA back and his DNA is on the knife sheath that is in the home at the location near two of the murder victims, do I need to call a live witness and subject them to initial cross-examination and give the defense 2 bites at that witness? Not necessarily. Do I want to put a witness who is likely traumatized through 2 court hearings? Maybe not. Can a police officer testify to what they were told in interview at preliminary hearing, which is hearsay for trial, but allowed at preliminary hearing? Maybe. I might just do that, because then you don't have to have that witness live and in court. And I appreciate that. So that's a strategy call for the DA. So what do we expect in a 4 or 5 day preliminary hearing? Experts to testify about the cell phone, because you can't just be like, oh, and then we saw the cell phone ping. You've got to bring in the person who determined all of that and told the police officer. You might have people establishing the cameras and how they saw the car, the FBI agent that determined the car. Preliminary hearings are generally very heavy in police officer and expert testimony, not always as heavy on witness testimony, depending on the case. Sometimes yes, sometimes no, depending on the DA's office and all of that. So I'm going to get to questions. That's kind of my initial thoughts. I'm sure that we will hear more from this. I want to go see if Chanley Painter had any other information or observations from being there in court. I don't know how reporters do it. I'm very clear that I'm not a reporter. I like to wear my slippers and be in my house and stream. But it seems that Chanley's been in Idaho like for fucking ever. Standing out in the cold, doing reports with Court TV night after night. I don't know how she does it. And then Bryan Entin is there as well. This is not where they live. I can't imagine it. Oh, Chanley said Bryan Kohberger had shackles on his ankles. In fact, when he walked into the courtroom, all we could hear were the clanks of those shackles. That's very interesting. So he didn't shuffle as if he was shackled, so they might have a little bit more give. Normally, if they have a shorter give, there is a very particular shuffle to get into court. So it's good to know. Yeah, and Chanley does it all while looking amazing. Always. I don't know how. So Chanley said that he did have shackles on. We couldn't hear it on TV, which was interesting. The defense waived preliminary hearing. So that's what we know. All right. So let us move on to your questions. I'm going to just swoop, and then we will go on to our other topics, which is a little out of order, but I know there's a ton of questions about this, and it's kind of hard to move on and talk about Girardi and American Express getting sued when there's so many questions about this, and this is kind of top of mind. And y'all let me know it's top of mind. Yesterday's podcast has done tremendously well. So thank you for finding my content. For those of you that are new, for subscribing to the channel. This is what we do here. So let's go to questions. I'm going to grab them as much as I can. Question: what would he need to present in order to get bail? Significant evidence of his innocence. This is a great question, Shelby. No. So bail is not based on how likely you are to have done the thing. Bail is how likely you are to be either a threat to the community or the public, or how likely you are to come back to court. I talked about this a little bit on Tuesday, because we talked about the bail hearing for the Girardi case CFO, and the court was weighing that. The court wasn't really weighing in that case threat to the community. Like, will this person commit more crimes? In a case Like you have a case where somebody's on like their sixth DUI and they've injured someone. The court might look at that and be like, I'm not sure that you're going to not get in your car intoxicated and kill someone. So your bail is going to be set high enough to ensure that, or you're going to stay in custody to ensure that you're not doing that and not driving. We'll set these other conditions. They set like ignition interlock devices where you have to blow into the ignition before you can drive. All these things to protect the community if you are going to be out of custody versus are they likely to flee, which is what we saw in the Girardi CFO case. The court's just like, what? And the DA, not the DA, the AUSA, the federal prosecutor was like, he liquidated all of his assets, sold all of his shit, already had established a home in the Bahamas and told people he wanted to change his name and hide. I'm not sure he's going to come back to court if you let him out of custody. Like, I'm not so sure we're ever going to see this individual again. And then we're going to have to spend time and money and resources going and tracking them down. So it's a balance of the two. So what would Bryan Kohberger need to show? That he's not a danger to the community and that he will come back to court. But in a case this serious, the presumption is no bail. So the defense would have to put on a substantial showing. I don't know if they're going to do that. I don't know if they're going to do that. Also in this case, if I'm the defense attorney, one of the conversations that I'm having as I talk and put on lip gloss, it's a skill. One of the conversations I'm having with the defendant is, if you are out of custody, will you be safe? If you are, not just will society be safe from you, but will you be safe from society? Like this dude, what shows up to the grocery store in this community, we saw the pain and outbursts in the Daryl Brooks case of people in court screaming, rotten hell, you piece of shit. You can see emotions running high. And when emotions run high, people don't always make good choices. So in this case, as a defense attorney, there's also a conversation about, are you as a defendant safer in jail? Or at least I think there would be. Can you be kept safe even if you're on house arrest at your parents' house? Or his parents live in Pennsylvania, so they don't even live in the jurisdiction. He would have to live somewhere in the jurisdiction and be monitored. But how do you put those people at risk that you're staying with, of people coming to the house, not meaning to do well? Because again, there's a presumption of innocence, but also there are people who are just like, fuck this guy, he's guilty. I don't think that's right. He has a presumption of innocence. The evidence against him is not great for him. It's going to be a hard case. But again, we haven't even seen all of the evidence. We don't know where the holes are in the story of the roommate. If there's a lot of questions unanswered, but it doesn't mean that people haven't already decided whether he's guilty. And it doesn't mean people won't try to take justice into their own hands. So all of that needs to be taken into consideration. So question, what is a gag order? A gag order is we don't talk about Bruno. Like, you can't talk about it. So this is a case where the court wants everyone to shut the fuck up. So the gag order, and I went over it more, I think on Tuesday and last Thursday, but the gag order essentially says those involved in this case, lawyers, investigators, whoever, can't make statements about the case outside of court. And that's what it is. American Express getting sued. Oh shit. Yeah, we're going to get to it. So why are gag orders used? To get everyone to stop talking. I also think that gag orders might have been asked for in this case, because not only does it get everyone to stop talking, but it also is a benefit to all of the attorneys in this case, because the media knows and the public knows that they can't really ask much. It's like, there's a gag order. It's like, you get to blame your boss. It's like, sorry, man, I can't help you. Go talk to the manager. Like, the court said no. And also, this is a small community, so they're going to be drawing from a reduced jury pool. So this keeps information getting out in a non-official way. So the only thing coming out is what's happening in court and what's happening in court filings. So different courts use them for different reasons. I think in a case like this, I can understand why the court does it. And the court has to balance the defendant's right to a fair trial and the public's right to open court processes. And I think the court has struck that balance at this point well. The probable cause affidavit was unsealed, so the public gets a bit more answers. Court hearings are allowed to be shown even though they're not shown contemporaneous, which is fine. We still get to see what's happening. So we know 15 minutes after it happened. Does it really matter all that much? No, I don't think so. We know what's happening in court. So I think it's fair. I think it's fair. So hearsay is permitted at preliminary hearing. Yes, kind of. There are each state has its own law for how that's allowed, but officers are allowed to say, I interviewed this person in this, because officers are trained. So officers are allowed to retell what a witness, were they in court, told them, because that evidence can come in through that witness later. So yes, certain types of hearsay are allowed in through police officers who interviewed them. It's not like I could go in. I'm not a police officer. I'm not someone who's doing interviews. I can't generally go in and say, oh, I heard this and that. But the rules of evidence are a bit looser at the probable cause stage of the hearing. Tina asked, wouldn't American Express also be one of the creditors? They are. And when we get to the Girardi stuff, we'll talk about this. I love that you guys are interested in this because I'm fascinated. What happens when these lawsuits are going down with the bankruptcy trustee is that they're asking that the creditors aren't allowed to make their claims. So that's a big part of it. It was mentioned that he can't afford a private lawyer. Don't remember who said that, but it was shortly after his arrest. It happened in the first court hearing. The court found that he was going to be appointed a public defender. So that's not uncommon. I mean, they're not looking at like his parents, how much his parents' house is worth and shit like that. He's a college student, a PhD student, but he's a student. So they're looking at how much money he has. And I'm not surprised that he does not have enough money. Is it only the DA who brings witnesses to the preliminary hearing? No, the defense attorney has a right to bring witnesses. It's just very uncommon, because why does the defense need to? If I'm a defense attorney, I'm like, this is a probable cause hearing. It's generally going to be bound over. The standard is very low. I'm not giving you a look at my witnesses that I don't have to tell you about yet. Unless there is something that is going to like get you out of custody, I'm not bringing witnesses as a defense attorney to a prelim. I'm poking holes in the DA witnesses and nothing else. Because also, if you go to preliminary hearing, sorry, my hair, this is why I don't wear my hair down, so I don't end up fussing with it on screen. But now something's on my lip gloss. My own hair is attacking me. Darn it. Because if I'm the defense attorney, I don't necessarily want multiple transcripts of my witnesses, because we saw it in Depp v. Heard. Oh, well, in this hearing, didn't you say this? And in that hearing, didn't you say this? The more transcripts, the more difficulty generally. More statements, more problems, often time. What's weird is thinking that is the last time I actually coded 5 times in 2 days. And actually, wait. Vamp Faye, I am missing the rest of the story. I'm sorry. I am sorry. Last time I coded is I was thinking computer coded, not coded at the hospital. I am sorry that was your experience. That's a lot. And the law nerds are a good group to cheer people up. Carrie asked, question, have you seen the post from about 10 years ago from Forms saying he had depression? I haven't. It sounds like Idaho doesn't have a not guilty by insanity. Idaho may or may not have a not guilty by reason of insanity. Here's the thing that people don't always consider when we're talking about like an NGI. First of all, Darrell Brooks didn't qualify for NGI, so let's just keep that in mind. The standard for NGI is very, very, very high. And when you're getting to an NGI or getting to a not competent to stand trial, you end up going to a locked medical facility. You don't get out of custody. You get locked into a medical facility. So it's generally a you can't stand trial. And NGI is fairly rare and really limited to extreme forms of schizophrenia where people truly did not know what they were doing. We're not acting on, I'm doing this thing. They were acting on something else. It takes a tremendous amount of medical information to establish that. And someone who is just working as a teaching assistant as a PhD student, I don't think is going to qualify for the type of impairment that is necessary for an NGI. Do you think they will try to get bail? It depends on what the defendant wants to do. And for the reasons I said above, I wouldn't be surprised if they don't. Question, can people who are harassing the surviving roommate be pursued legally? It depends on what they do. I think it's distasteful. You guys know that I have my own way of interneting. I hope that the surviving roommate is just not on the internet, which is hard for someone who is a senior in college. So much of the world happens on the internet, unfortunately. I hope that they are just leaning into the support that I'm sure they are getting in person. I very much hope that when they have to return to school or go to classes, that all they are getting met with is support and everyone else just keeps their thoughts to themselves, because you never know what you've been through. And our society can always do well with a bit of compassion for people until we know more. It's fair to have questions. Everyone has questions. Why this and why that? Fine. But when the questions also come with judgment and vitriol, it crosses a line for me. So I very much, was that thunder? Yep. I very much hope that in person, this roommate is being met with the support of their peers, and that they're able to stay off the internet with people who don't know this individual, don't know the circumstances, and don't know how they would have reacted. Brains do weird things, and we just don't know. So we will hear more. I will also say, as I said in the podcast, and the more I think about this, I mean, I talked about this in the behind the scenes members only portion of the podcast. So when I record the podcast, I will often do it with the members on a live like this, record the podcast, and then clip out my interjections or me looking for a document or me going, oh my God, I said that terribly. Let me retake it. And one of the things I was talking about is, from my experience in college, first of all, when there were multiple roommates in a lot of places, there were always people in and out all the time. This is also a sorority, or not a sorority. This is also a group that had been at Sigma Chi at the fraternity house. I don't know if any of the female victims were in sororities, but Entin was in Sigma Chi. Sororities and fraternities prank people, kidnap people, do things in the middle of the night where you're like, why am I dressed in yellow and meeting somebody at a truck stop? This seems like a terrible idea. That's maybe a personal story, but things that maybe would seem odd in my life as a 40-plus-year-old woman might not seem weird when living with multiple college students that are involved in Greek life. Also, if everybody was out for the night, the fact that a roommate might have somebody over that you don't recognize is not all that weird. So even if you get the creepy feeling, do you want to be the person that's like that person that's getting your roommates in trouble? Also, what if your roommates have something that maybe you don't want the police to see? And so then you call the police and then you're getting your roommates in trouble. Like, I would be the person who would be like, I don't want to be that person like who took everything too seriously and then got everybody in trouble. And you never know why people might not want to call the police. There might be reasons. People are like, oh, if this is if I'm in college and I have a bunch of roommates that are drunk and something weird kind of happens, am I going to think twice about not wanting them to get in trouble for being drunk if they're underage, or for having alcohol in the house if people are underage, or for having, I don't know what the weed laws are in Idaho, for having weed or whatever else? Do I want to be the person that's getting all my roommates in trouble? No. Would I be afraid that I'm overreacting? Yes. Would I second guess my instinct that something is off and be like, I'll just wait until the morning when I can think about it more? Maybe. I don't know. So there are so many reasons that this roommate might have not called the police, and we won't know until they talk. But I can imagine a lot of non-nefarious reasons why a college student might make that choice. Also, these are college students. Do I always expect them to make a decision that in hindsight all of us might make? No. They're growing and developing and learning. And I think your brain doesn't immediately go to, I mean, unless you're very deep into the true crime world where every rattle, your brain goes to somebody's breaking in to kill me. I think most people don't think that first. And so it makes me really frustrated to see the harassment online. But there's these boundaries of what people are allowed to say in free speech and mean words. And then there's a boundary of harassment, cyber stalking, doxing, and things like that. And so it's a hard balance. So have I seen anything that can be pursued legally? Not really. And that's unfortunate. I can only ask everyone to internet better. Will there be a jury at the preliminary hearing? No, the judge is the finder of fact at the preliminary hearing. I wonder why the prosecutor decided to do a preliminary hearing instead of getting a grand jury indictment. It might be their standard of practice. In smaller jurisdictions, they don't always have easy access to convene a grand jury. So it might just be that that's how they do it. Also, I'm kind of glad, because a grand jury we would never know about. So we would see an indictment and that's it. At least with a preliminary hearing, there's a chance that we will get to see that live and get to know more about this case. So I'm glad for that. Question, the TikTok psychic created a new account posting the same defamatory story about the history professor. Will that be factored into the lawsuit or will they have to file a new lawsuit? They can amend this lawsuit for additional defamatory statements and in fact set it in the defamation lawsuit that this hasn't stopped so that this suit is entailing or should encompass more statements. The fact that TikTok stopped the account in some way and then they made a second account to keep going, I think will factor in, especially if it goes to a jury. A jury is going to be like, but why didn't you stop though? They're going to ask those questions. So all asking, Emily did talk about the TikTok terror lady. It was on the last Emily show. Yes, it was yesterday. It was yesterday's podcast and the video is, YouTube is now segmented like videos and live streams. It's under the videos because it's a podcast. Question, what's the difference between a grand jury trial and a jury trial? Charisse, this is a great question. A grand jury is a special proceeding where it is a sealed and secret proceeding and there is no defense attorney present. There are rules about what the prosecutor must present. They must present exculpatory evidence. So it's like they kind of play both sides. The prosecutor plays devil's advocate, if you will, and showing like the positive and the negative, but they prevent information from getting out. So the feds almost always grand jury things, and then you'll see the indictment come down and a grand jury is convened. They hear the evidence. There is a different standard again because this is probable cause. At a jury trial, the criminal standard is beyond a reasonable doubt. It's a unanimous jury, and they all have to decide, and they're convicting someone. A grand jury is indicting someone, so they're taking that probable cause determination and going, I think it's likely that this person might have done the thing. Yeah, more like it's likely. It could be. It could have happened. So it's enough. And that's what an indictment is. So thank you for asking the question so I could back up and explain it. Question, when the trial begins, is it highly likely the jury will be sequestered? No, sequestration is expensive. It is not likely. And I don't know if a trial will start in this, but no, sequestration is the exception, not the rule. Will they potentially have things like we saw, was it the Rittenhouse jury that had like a bus with like blacked out windows or papered over windows that took them to an offsite parking lot so they couldn't get followed? I think it was that case. Might we see those kinds of things for jury safety? Maybe. But sequestration prior to deliberation is an extreme and unusual thing. So if the police do a search warrant at his house, can the defense attend the search? Generally, those things happen before the defense is on the team because they happen prior to arrest. If additional warrants are carried out, the defense will get the information after the warrant is carried out. But if they are doing something that the defense needs to be advised of in advance, they can. Well, I don't know the circumstances when that would happen. Most of the search warrants are probably done. But when they do search warrants for documents and things, those will all be turned over. The results will all be turned over. But we did see a stay of the remediation efforts so the defense had access to the crime scene, which is unusual for the defense. Normally, the crime scene is long done and wrapped by the time the defense gets it and they get reports and photos and stuff. But that's the same with DAs. The DAs are not often at a crime scene. In a case like this, the DA probably would have walked through it, but it's not the usual circumstance where even the prosecutor has an opportunity to see the crime scene. It's normally relying on investigators. So it would be very unusual that would happen, and it depends on the type of search warrant, but they get all that information afterwards. So why can't you offer hearsay? Are you not an officer of the court? As a lawyer, I'm an officer of the court, but I am not a police officer. So there is training police officers get to take reports and offer testimony that allows that exception to the preliminary hearing rule. I need to go look and see what the 115 equivalent is in Idaho. So Joanne, can you please explain waiving speedy trial, etc.? There are statutory and constitutional rights so that the government can't lock you into custody and be like, we'll take you to trial in 4 to 5 years. So there are times in Idaho, you heard the court say you have the right to a preliminary hearing within 14 days of coming before this court. So there's a timing from when you're arrested to when you have to be arraigned. It's normally 48 hours. So from the time you're arrested to the time that you are arraigned, there is a limit. So you can't put somebody in custody and then not bring them before a court to hear the charges against them for 30, 60, 90 days or longer. You can't do that. You have to bring them to court and arraign them on the charges. You're charged with this, or you have to let them out of custody. That's the other option. So there's a timing for that. From the time of that arraignment, there is a fixed amount of time. In California, it's 10 days. In Idaho, they said 14. There is a fixed amount of time that you have to have a preliminary hearing. And that preliminary hearing says, these are the charges against you, arraignment. Now this is the minimal amount of evidence against you to tie you to the crime. Some of those preliminary hearings can take literally 15 minutes. Officer, do you recognize this person in court? Yes, I stopped this individual on this date and time, and they had an open bottle of alcohol. They smelled of alcohol, and they failed the field sobriety tests. Okay, thank you. Defense, any questions? So sometimes preliminary hearings can go very quickly. Sometimes they take longer, but they just show probable cause that the person in custody is likely the person that committed the crime, and then they hold them over for trial. Then there is a speedy trial right within statutory or constitutional amount of time, and it varies by jurisdiction. You have the right to a trial again, so they can't just hold you for years and years and years without going to trial. In the Murdaugh case, he didn't waive it. So that trial is going to trial at the end of June. He did not waive his right to speedy trial. He's like, oh yeah, you want to arrest me? Bring it to trial then. And this is why the feds will often indict people after their investigation is completed, because if the defendant doesn't waive their time for speedy trial, they're ready to go to trial when they indict someone. The investigation is not still ongoing. In a case like this, when you have 4 homicides, this investigation is still very much ongoing. They are getting additional information. They are continuing to work and put pieces together and build their case. They're very much still working. And the defense attorney is going to be working too. So that is the right to a speedy trial. You have a fixed amount of time to go to trial. So it can be, let's see what it is in Idaho. I just look up the time because again, it can vary by jurisdiction, but that is a constitutional right. Limit. Let's see. God, Google is so great. Let's see. This brings us to the Idaho statute. And let's just answer the question directly together. Let's all research together. So the first thing I look at to make sure this is actually the Idaho statute is that this is a .gov website. Great. Criminal procedure, dismissal of an action. When an action may be dismissed. Let's make sure this is the right statute. Let's see. Miguelina, yes. Just let me know what time. Let's see. When a person who has been held to answer for a public offense, if an indictment or information is not found against him and filed with the court within 6 months from the date of an arrest. So this is, let's see, when an action may be dismissed. So this is part of your appropriate time if a defendant whose trial has not been postponed upon his application, waiving time, is not brought to trial within 6 months from the date of the information is filed with the court. So 6 months is your speedy trial right, and if it's not brought, the case can be dismissed. If the defendant whose trial has not been postponed on his own application, waiving it, is not brought 6 months from that date, the defendant was arraigned before the court in which the indictment is found. So from arraignment on the preliminary hearing, if the defendant charged with the misdemeanor offense whose trial has not been postponed on his own application is not brought to trial within 6 months. So even on a misdemeanor, you have 6 months. So Idaho, 6 months from indictment, which means this is the timing. You have the arraignment timing. So from arrest to arraignment, there's a period of time, normally like 48 hours, sometimes 72 hours where you have to be arraigned. Then from arraignment to preliminary hearing, it's 14 days. Then from preliminary hearing, indictment, and charging document to trial is 6 months. That is your staggering of time. He has waived his preliminary hearing, so that goes out until June. After the preliminary hearing, if he is indicted, meaning the preliminary hearing is held, then it starts the speedy trial right of 6 months from June. He has not waived that right yet. That date backs up to when the preliminary hearing is done. Hopefully that makes sense. I'll go look. There's a lot of questions and I'm trying to catch up to not just super chats, but questions in the chat. So I'll go look. So thank you, Joanne. That was a fantastic question. Is the blonde girl the attorney? Yes, the blonde woman is the attorney who's going to be representing this defendant all the way through. So yes, the one that from the side looks like Shannon Bedore. The way I hate being filmed from the side. Look, we don't We don't always need everything on film. I hate it. And she's just doing her job. So let's see. Question, what's the difference between a preliminary hearing and a trial? Also, what is the speedy process they mentioned? So we just covered the speedy process, so this is a great point. The difference between a preliminary hearing and a trial. Trial is beyond a reasonable doubt. You are convicted, you will be sentenced, or you will be acquitted. They cannot try you again. Everyone's moving on. That will be determined by a jury in a criminal case of 12. Preliminary hearing is just a probable cause determination determined by the judge. Carolyn, question, will Bryan stay at the Idaho jail or get transferred to a larger prison between now and the hearing? No, he will stay in local custody. He has not been bound over to the Department of Prisons. So the jail system and the prison system are separate. You will stay in jail. Generally, if this jail is attached to the courthouse, that's generally where you will stay. He will stay in jail until he is convicted, if he is convicted. And at that point, will go to prison. So that's the difference in the system. For sure. So, to whoever gifted memberships, thank you so much for gifting memberships. I appreciate it. If Kohberger had a valid alibi, would speedy trial not be more favorable? This is a determination between him and his defense attorney, not always. Sometimes you need time to get it done. I trust his defense attorney has his best interest in heart. That is their job. So no, sometimes you need time to do this. There is a tremendous amount of evidence. So I don't think we can read into, well, if he was innocent, wouldn't he not waive time? I don't think we can read into that. He has a presumption of innocence, and his defense attorneys have to do their job competently. Also, this defense attorney is one of a very few that is death penalty qualified in the state. So for them to do their job ethically and to do their job well, to go through all of the information before a prelim on a quadruple homicide is going to take them a substantial amount of time. The police have gotten all of the cell phone search warrant returns. The attorney has to go through that. It's a tremendous amount of information. So they also need to do their job well. And they need time to do that, and have talked to their clients, looked at their schedule, because this is not their only case. They have to look at their schedule. This defense attorney could be going to trial in 3 weeks and is like, look, I'm unavailable for 2.5 months where I'm in trial and I can't work on this case. So there's a lot of reasons, including attorney scheduling, that can come into play here. So it's not always the best thing if your defense attorney is busy and one of a very few that can represent you on the level of case you're on, to push them to go before they are ready. They need to be ready. So that is my thoughts on that. So there's a lot to say. Did you see the paper talking about a co-defendant? I did not see anyone talking about a co-defendant. Do you have any idea why the prosecutor didn't convene a grand jury in this case? It might not be easily available to them. So, Andrea Burkhart did a video earlier today about Idaho not having an NGI defense. Okay, I trust Andrea Burkhart's research. Andrea Burkhart does an amazing job of saying, hey, what I want to do is dig into everything this state has. So if that is what Andrea Burkhart is saying, I absolutely trust her research and opinion. Her research is always right on, and she has a great YouTube channel. So I always appreciate it. Look, she absolutely digs into, like, let's take a look at this. And I love the way she kind of focuses on this case, like a case at a time, which is so helpful because she also, is still representing clients, something that I'm not. And then I end up covering 17 cases at once, and crazy. Do we know how many jurors there will be? Criminal case 12. Emily, did you ever feel uncomfortable because someone wasn't shackled? I would want that guy shackled. Well, I've had interesting experiences in court. We're going to just DA story time for a minute, and then we're going to go to some more super chats and questions. I've had interesting experiences in court. So I had a defendant grab me in court once. It was a juvenile defendant. It terrified me. I was, because I was sitting in court and didn't see, they were walking behind me, unrestrained. And so they grabbed me from behind. And so I was terrified. This juvenile court, I had yelled at the bailiff. This bailiff and I did not get along. This is the same bailiff that tripped and broke his arm when he was trying to chase a juvenile that ran out of this same courtroom. This bailiff and I did not get along very well. I was a real cranky bitch the entire year I worked in juvenile. I was not happy with a lot of things. So I was not always pleasant. Let's just be very clear. But the defendants in juvenile were often unshackled, not restrained by hands, not restrained by feet, not restrained in any way. Hence, the juvenile running the fuck out of the courtroom and the bailiff tripping over his own desk and breaking his arm. That's a story that I've told, but can tell more fulsomely on another day. So I already had issues with this courtroom layout because the way the courtroom's laid out, and it's really hard to talk without a visual, but from counsel table, I'm pretending I'm at counsel table. The minors came in through a door, walked behind the prosecutor, and then sat with the defense attorney. There are no jurors and no jury boxes in juvenile court. So it doesn't matter where the defense attorney sits. The bailiff is like, look, but the minor is more close to where my desk is. I'm like, this courtroom needs to be rearranged. We need to have the minors not crossing behind the DA, unrestrained with access to the DA and then sitting with the defense. The defense needs to be on this side and we can rearrange things. And they're like, who the fuck do you think you are wanting to rearrange this courtroom? I'm like, all of this seems like a bad idea. The minors have to pass behind the DAs and then are sitting where they have a clean shot to the door to the outside, not the door back to the lockup. So this minor, we finished the court hearing and the minor is walking behind me and puts their arms around me while I'm sitting in my chair, which scares the ever-living shit out of me because I don't know why anyone is touching me in court. Like, why are you touching me? Also, most juveniles were not making the best decision because most of our juveniles weren't horrendously violent. Some were very, very terrifying. Teenagers can be terrifying, man. So I was not thrilled. And then they started saying, thank you so much. Thank you so much. And I was like, are you trying to hug me or strangle me? Because I can't tell the difference because I am in court and no one's hands should be on me in court. Some of you will remember a story about a defense attorney, but no touchy. No, unless you've asked me to hug me, don't touch me. If you are in custody, please don't. This juvenile was just like, thank you so much, and then was grateful. And the defense attorney was like, don't touch the prosecutor. And the bailiff is like, the defense attorney, I'm sure, was terrified that the bailiff was going to like tase the minor at this point, because once you've put your hands on someone in the courtroom, it is a problem. The minor was trying to express gratitude, which again, teens don't see the world the same way. And so I don't think a teen trying to express gratitude understands how that can be perceived from the other perspective because a teen. So I was just like, it's okay. Like, it's okay. And then I was like, bailiff, you can't just let people touch me. He's like, well, it was okay. I'm like, what if it's not? What about the time that it's not? I am a mom. I would like to go home at the end of the day. It's not rare. I mean, it's kind of rare, but it's not unheard of that people wish to harm criminal prosecutors. It is not beyond that I have seen defendants bring pens that have been turned into shanks, try to bring razor blades into court. It happens. So just because it didn't happen this time doesn't mean it doesn't happen. You can't let people touch me in court. And it was okay. This bailiff and I did not get along. I was not pleased. I did not blame the minor. I blame the bailiff. The minor is a minor who is not thinking things through. I'm glad that the minor was not harmed. But when you put hands on someone in court, some deputies will shoot. It's not good. So I was not pleased because it scared the ever-living shit out of me. So how do I feel about people being shackled? Well, sometimes it can be concerning, but it depends on who the bailiff is. When there's bailiffs that I trust, I don't worry about it because I trust the bailiff and I trust that the bailiff knows the defendant. They get to know them when they're bringing them in and out of court regularly. I will say there was another defendant who was unshackled, who was getting ready for trial on a very violent string of armed robberies. I don't believe anyone died, but I think that was by luck. But on a very violent string of armed robberies, and I tripped and fell on them trying to leave the courtroom. And I thought that that was going to go very badly for me as I am tripping and falling onto a defendant, and badly for them. And they kind of pushed me by the shoulders back upright and were like, "Ma'am, are you okay?" So again, my oh my, court is unexpected. So yes, I have thoughts about it, but again, you if you trust the people that you work with to keep you safe, then you trust the people you work with to keep you safe, and then that's fine. So yes, I've told the tripping story a few times. It is seared into my mind. I was the fact that this defendant did not actually grab my boobs when I fell on him, like it was a thing to be said for this defendant. He was as terrified as I was. He was like, "Ma'am, you're okay." And this is before I had all my back surgeries. I was like actually functioning better. Well, that's why I was wearing heels before the back surgeries and everything else. But I felt so bad. I was mortified. The defendant was mortified. The bailiff in that situation was pissed at me because the bailiff is like, "Oh my God, the fact that you almost caused a fucking crisis because I don't need to wrestle you away from this defendant who is unchained." Like the bailiff in that case was like, oh my God, you have created a situation." I'm like, "I am so sorry." That bailiff was very worried. The bailiff in juvie was like, "Meh." I was not sad when he was off of work for a while to recover. I was like, So the tripping story, it's just, I'm a life is life. Like life is life. It's just, life is life. Let's get back to not DA stories, but answering questions. Huge congrats, Emily. Your star is rising. True, I don't know about that, but I definitely did a lot of thingies yesterday. And I will tell you when those will air, but that is why the hair is still like we're on second day hair. But I did get to do court TV last night with Vinny during closing arguments, and that was really fun. I was nervous. It's been a while since I've been nervous about stuff like that, but I was really excited to be on court TV. I grew up with court TV. Court TV is iconic. I was just like, and Chanley Painter was doing the reporting before me. I was like, I'm on court TV. Next time I'll remind them that it's Emily D. Baker, not Emily Baker, but potato, potato. So much love for everyone that donated to Hoeg's GoFundMe. This community is the best, absolutely incredible. And so it's why there's always I'm never going to be like, fuck the internet. The law nerds are the best. There are very huge, bright spots to be said when the internet lets us all come together and discuss things. There are also, TikTok psychics alleging that people committed murders. It's the internet being the internet. Bree said, "Thank you for wishing my son a happy birthday on Tuesday. He was so excited. He said he couldn't wait to go to school and tell his friends." Well, tell him thank you. My son has my kids are not impressed at all that I'm on the internet. So Bree, tell your son thank you. That makes my day. Absolutely. Purple Pine Kush. I saw this too, that Jeff Beck passed away yesterday. I was stunned when I saw that, when I finally got back around to being on the internet, not just looking at cases yesterday. I was really, really surprised. And so sad to hear. I watched all the TikToks and written more info for you. I messaged you through LinkedIn. Ooh, I'm generally not on LinkedIn. My public email address is the best way, and my team will make sure that I see it. So just be like, Emily said to send this during her live stream, and I will take a look. Thank you, Michael. So public email address is the best way because it does get to me. Do you think they will be recording and releasing the trial itself in some way? I hope so. I hope that they will allow that to stream in some way, even if it's on a 1 hour delay. I hope they'll allow it to stream. So what would be awful is if they waited till the end of the court day at 5 p.m. to start coverage. Can you imagine? We'll just become vampires. We'll just sleep during the day. It's wild. I also have natural purple hair. Are you my long lost sister? Obviously. That's obviously what it is. Yes. Us and our purple haired gloriousness. Yes. Always. Rand said, medical in the US is insane. Have a GoFundMe for my wheelchair. Who knows what insurance wouldn't cover for Hoeg? Every bit makes a difference. It does. And then Hoeg, unfortunately, because you can't plan life, Hoeg went into the ICU at the very end of December and then was transported to rehab at the beginning of January. So you've got to meet all of your deductibles for 2022 and then all of your deductibles for 2023, which is just, it's just because there's never a good time to have a medical emergency. But the worst possible time is straddling one year to the other. Is it bad that I'm playing two dots now? No, it's glorious. Question, who is his attorney? Will she become a topic of discussion? I hope not. His attorney seems, from everything I've seen, to be highly competent, very experienced, and tremendously well respected. So his attorney is doing her job, is qualified to do her job, and I don't think should be a topic of discussion much, because again, everyone has the right to a defense, and that's exactly what the attorney is doing. So that's everything I've seen about his attorney, is that tremendously well regarded. Like hospital unit secretary, respect and treats. Yes, exactly. Respect. Treats sometimes help. Except at the beginning of the year, everybody started doing like keto and stuff every year at the beginning of the year. So maybe keto treats. Emily, will he be in prison the whole time? It seems at this point that he will be in jail and in custody pending the preliminary hearing. They have not made a bail motion. If they do, I'll cover it and we will watch it. We will know about that. If there's a bail motion, it would be a full evidentiary hearing. Where are you staying? How are you staying? And the judge will make a decision, and that would all be very big news. Will there be any chance that the defense attorney may change? There's always a chance, but it's unlikely. But again, life is unpredictable. So I don't think it would be an expected change. You normally won't get a defense attorney asking to be removed from a case like this, but things can happen and anything is possible. So do I expect it? No. Is it possible? Yes. Emily, all the evidence I've seen seems circumstantial, and a good defense attorney could explain reasonable doubt. Thoughts? Yes, a good defense attorney can ask for reasonable doubt. Right now, all we have is probable cause. That's all we've been provided. I think we do have probable cause. Circumstantial evidence is evidence. There's really interesting jury instructions about it. So I think all the evidence we've seen is enough to establish probable cause. And I think I can see, and if you watch the video where I go through the probable cause affidavit, I can see where they will tie those things more. But yes, criminal trials are a puzzle, and you put the different pieces together. There doesn't have to be an eyewitness that said, I saw this person do this thing. This will be a circumstantial case. There's not video of these murders that we know of. And if there was, I'm sure we'd hear about it in the probable cause affidavit. There's not like in-home video in the house. We have a witness in the house who saw somebody leaving, but we don't have like that evidence. So all of it's going to be circumstantial evidence tying it together. But when they get the DNA back on that knife sheath and then tie everything else together, plus the description from the roommate and his general description, I think they can build a very strong case. So hopefully that helps. Will this be the same judge in the prelim? The judge we're hearing in these hearings will be the judge for prelim, and then it will go to a different judge after prelim. I have HoegLaw auto playing on my other device nearby, just sharing in case it is the good idea. I think it is. Hope so. Thank you. Thank you for engaging with his channel. I think that's a great way to make sure that YouTube remembers how much we love Hoeg's content. Could waiving a speedy hearing affect negatively his case? I think it's only good for him. Truly. Again, his defense attorney is going to make that decision, but I think it makes sense. Who are his lawyers, top notch or generic? I heard O.J. Simpson caliber. I've heard nothing but the fact that that this lead attorney is a fantastic attorney. So that is what I have heard as well. Is he allowed family visitors? Generally, yes. Each jail has its own conditions for when that can happen, but I haven't seen anything that would indicate that that's not allowed. Is it unusual for them to take 5 days for a preliminary hearing? This is one case, but there are 4 murders that are going to be carried out distinctly. So no, it doesn't surprise me, because a homicide prelim will generally take a day. So when you're looking at breaking down 4 plus the amount of cell phone evidence and stuff, I'm not surprised they set aside a week for it. Will they use the whole week? Maybe not. But the judge would rather have the time and not need it than not have the time and need it, because then the judge has to bump all the other cases, and then other attorneys are like, I'm sorry, judge, we had this scheduled for Friday. I can't bump it to Monday because I have these things. So now it's going to go out another 6 weeks or more. So court scheduling is one of the hardest things in the world. I had a case with 12 defendants, and trying to schedule all the lawyers to be in court on the same day it took like 45 minutes every single hearing. It was wild. Do defense attorneys have other cases or solely work on yeah, other cases. And probably because they're a public defender, they are a death penalty qualified public defender. So they probably have a number of other cases, and all of those other cases are also probably pretty significant homicide cases. So not just more cases, but more very serious cases where literally the consequence for the defendant could be life or death. Fun fact, the familial SMP DNA technique is the same one they use to catch the Golden State Killer, trash snipping and all. If you want to know more about why they wanted to get and related DNA. I have my own theories about why they want a related DNA. It made sense to give them that last bit of probable cause because once they arrest the defendant, they're going to have his DNA. So it made sense to do it in the probable cause. But yes, familial DNA can be very, very helpful, especially to get someone in custody and then get their DNA. Penn asked, do you have the chance to not represent someone like Bryan if you're a public defender? Why do you think some lawyers defend guilty people? Thanks. This is something that Natalie Lawyer Chick talks about a lot on her channel. Ian Runkle the Bailey's also a defense attorney. A lot of the defense attorneys that I have had the pleasure to know believe in our system of justice and believe that the government should not overreach and that everyone has the right to a defense. Everyone is presumed innocent, and the check and balance in the criminal justice system are the defense attorneys and the prosecutors. Those are the checks and balance, is that adversarial system, making sure that the government adheres to the law. They don't violate the Fourth Amendment when they go and collect evidence. They don't violate the Fifth Amendment when they comment on the defendant not giving an interview or not speaking until they testify, like the prosecutors did in the Rittenhouse case. The defense is the check and balance on that. So people who believe in a strong system can easily say, this person might be guilty, yes, but they still deserve to be prosecuted under the law and the Constitution. So Natalie Lawyer Chick talks about it a lot on her channel from her experience. Of course, I have never been a defense attorney. I am a control freak. It would be very hard for me to be a defense attorney. As the DA, you get to make a lot of the choices. As the defense attorney, you have to react to a lot of those choices. Though I would say defense attorneys get to do way more cross-examination than prosecutors do. And I love doing cross-examination. So I could absolutely see saying, I want to cross-examine people and I want to make sure that the Constitution is adhered to. I could absolutely see those as reasons to become a criminal defense attorney. Absolutely. So it's a very important job and our system doesn't work without it. So, but Natalie does talk about that on her channel. Runkle talks about it. And it's a needed job. And defense attorneys, especially public defenders, do not always get the respect they deserve. It's so funny because you look at defendants who are like, I don't want this government lawyer, blah, 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 blah. And I look at the caliber of defense attorneys that are privately retained that come into court, and then the caliber of defense attorneys that are public defenders. I'm like, you're better off like with the attorney you're assigned. They're an excellent attorney. Like, it's just to be an attorney, to sit there and be like, I am one of the best attorneys in the, not me, for a defense attorney who's one of the best attorneys in the jurisdiction, who's a public defender, to have these defendants be like, I don't want this public pretender. It's wild to see. It's like, this is one of the best trial lawyers you could get. You couldn't afford them. And they sit there and just kind of smile and just are like, well, Your Honor, you've heard how my client feels. It takes a very, very patient human to do that. So for sure. Everyone needs an awesome defense DPKs to ensure the verdict sticks. That's true too. Can they use BK's DNA, start comparing to cold cases before he's convicted? I've been asked this a couple times. These investigators won't, but once his DNA is in the system, some of those systems will automatically start running checks. So that can happen on background. These investigators aren't going to start actively looking for more unless they have something that really, really is top of mind in their jurisdiction in a time frame. They're focused on these 4 homicides. Could others now that his DNA is in the system, we're assuming that that's already gotten into the system. Do that maybe, but some of those systems also run automatically depending on the jurisdiction in the system. But I am not a DNA expert, but some of those systems, once it's in, it can now be compared. It's clear to me from the probable cause that his DNA was not in those DNA databases before his arrest. It will be now. What happens if a defendant confesses to their lawyer but doesn't want to plead guilty? How does the lawyer defend them? The lawyer defends them by trying to raise a reasonable doubt, the same way they would if the defendant didn't confess. Or the lawyer can then give them advice of, okay, you don't want to plead guilty. Let me run these scenarios down with you. Let's just A/B this real quick about how this is going to go for you. And a lot of defense attorneys will be like, I know this, judge. If you plead guilty, you are going to get less of a sentence. If you go to trial and are convicted, you are going to get a heavier sentence. Or saying, look, you're right. You might have done it, but the police fucked up and they got evidence that I think can get excluded. Let's try to get that evidence excluded. That's their job. It's not whether somebody did the thing, it's whether the government can prove that they did the thing beyond the reasonable doubt on legally obtained evidence. That is really, truly the question. So, if presumed guilty, you lose all your rights, then we don't really have rights. I agree. Defending everyone innocent or guilty is important. I agree with you. Summer Rain, can you imagine trying to prove yourself innocent? It's like, hey, you've been accused of witchcraft. Prove you didn't do it. Good luck. That's not the system that we want, and it's not the system that we have, and I'm glad for that. Our system, though, errs on the side of the guilty going free versus the innocent remaining in custody. That is not always perfect. Yes, innocent people get convicted. It's getting better as technology gets better and as society advances, and as biases and things are starting to temper a bit. Yes, innocent people get convicted, but is it the majority? No, it is a rarer circumstance. But also that doesn't take into account all of those that are arrested under odd circumstances and plead guilty because they're like, well, I did have drugs in the car. So our system leans towards letting the guilty free versus keeping the innocent in custody. That is the way that it should work. Does it always work perfectly? No. Is it better than a lot of countries? Yes. Question, what differentiates a lawyer as being death penalty qualified versus not? State by state, it can vary a little bit, but it ends up down to experience. You generally have to have tried a death penalty case as a second chair, and you have to be qualified through generally the state licensing and there are some classes that you have to take in continuing legal education that you have to take to make sure that you are an attorney that is qualified to do those kinds of cases. Because a defendant could just go hire a lawyer that's never done a murder trial before and be like, hey, do this. They've started putting in safeguards so these cases weren't getting overturned based on ineffective assistance of counsel. If you've never done a murder case before, your first one shouldn't be a death penalty case. You are going to always learn based on every case that you do. The more trials that you do, the more you learn. The less trials that you do, the more you say, what if any? My opinion. Did you miss my super chat? No, I haven't gotten to all of them yet, but I will. I tried to balance both, and we have lots of times for questions today. Question, did you see Peter's stream this morning with his attorney giving an interview to the journalist? No, I didn't. Whose attorney? I have questions. Jennifer, will you let me know whose attorney is giving interviews to what? Ben Chu, snark in what world? Question, how does a defending lawyer feel if they help someone get free and that person commits a more heinous crime? Does it happen? I've not been a defense attorney, so I can't tell you how somebody else would feel. It's a great question for Runkle or for Natalie. I imagine that defense attorneys, if they have questions about somebody, they're like, hey, you're getting out. Make good choices. I don't want to see you back here. I will say that there are times when cases I've been prosecuting, the person is out of custody and has committed more crime, and it always makes me feel a little sick to my stomach. It was always frustrating, and it's a balance, right? Because you can't just keep everybody who's ever been accused of a crime in custody. And so it's a balance between how you try to decide who is a continuing danger and who is not. And sometimes you just don't know, and you just can't know. And there's a balance between the defendant's rights and the community safety. And it's not always a perfect balance. So I don't know how defense attorneys feel. I know how I felt. It frustrated me. And sometimes there were times when I was like, with a newspaper yelling to my office mates, being like, the way especially if I had asked a judge to keep someone in custody and they didn't, then I want to march into somebody's chambers and be like, and this is why I asked. So, but you can't do that either. So, and judges know, and you make the best arguments you can. And at the end of the day, it's on the judge. How do the judges feel if they've let somebody out of custody and then they go and commit more crimes? I don't know. I would love to ask the judge who didn't hold Daryl Brooks in custody how they felt. I don't know. I can't imagine that they feel good. I imagine that they're like, well, I didn't see it going that way. I imagine that it weighs on them because of he went on to commit a substantial amount of more damage when he could have been in custody. So, is someone pleads not guilty and goes to trial, could they change their plea in the middle of trial? Yes, I've actually had cases where that's happened. The judges aren't always thrilled by it, but the jury gets very confused. They're like, wait, what? And it's like, oh no, it's resolved. Thanks for being here. Yes, it can happen, and it does. That varies on jurisdiction and the judge, but yes, it can happen, and it does. So question, what is speedy hearing? We went over that very thoroughly. Thank you for the super chat. The Great Big Geek, are you going to be covering the whole case of the TikToker and professor? I did. Yesterday's The Emily Show covers it, so you can find that on YouTube or your favorite podcasting app. Joining late, thank you, Replay Crew. I don't even think I gave love to the Replay Crew this morning. Love it. Thank you, Replay Crew. And thank you to everyone who's new. You did the subscribey things, we binged. Joining late but watching the whole show, wanted to make sure that everyone, new host family, also asked for get well cards to be sent to his office. I'm sure that information is in the GoFundMe, but yes, his office is his most public facing address, so he can be flooded with cards. Are you covering the Massachusetts missing person case? I've seen it. I don't know how much I'm going to cover it yet. I know there's been an arrest in that case, but we are not far from the Murdaugh case going to trial, and I've got a bunch of stuff I need to catch up on before coverage starts, because we are starting day-to-day trial coverage. So I might touch on it next week, but we are starting day-to-day trial coverage, I think, on the 23rd. So we have like 2 more shows and 1 more podcast before we're in like 4 to 5 weeks of trial mode. So it's a balance, and I need to get my nails done. And trying to find time to schedule getting my nails done has been ridiculous. These are the things that I worry about. Question, if the defendant comes back before as a match before the evidence trial, does it affect a future proceeding? I'm not sure I understand. If I think what you're asking is if the defendant, so like in this case, we know that there was a knife sheath with DNA on the button of the knife sheath that is male DNA, and we know that that male DNA is most likely someone who is the biological son of Bryan Kohberger's father based on the familial DNA. So we've not heard any word that Bryan Kohberger has a brother. So what we can now assume is that once they have Bryan Kohberger arrested, they are going to take all his DNA and then rerun that DNA against the suspect profile from the button. They will get that DNA back before this goes to preliminary hearing. Does it change things? No, they'll just turn it over to the defense attorney, and then that information might come in at the preliminary hearing instead of using the familial DNA, if that makes sense. The last one should have said Hoeg. No worries, and thank you you didn't have to correct it on a super chat. My brain can correct it most of the time. Kathy said, love you covering all these cases. Can't wait for the Murdaugh case to start. P.S. Love the purple hair. I'm loving the color it's become. Like, we keep going through different variations of purple, but I'm loving the color it became. When I went on vacation, I was nervous about how it would hold up to the ocean water, and I am thrilled with what it has done. I think this is one of my favorite versions of all of the purple. Kathleen says, if venue changes, is he transferred to a different jail or transported every day? It really depends on the jurisdiction. Either can be. If there is an in custody option nearest to the courthouse, that gives less potential for problems for the sheriffs. So in LA, people are bussed all over a very large county to get to court. In smaller jurisdictions, you often have the jail connected to a courthouse, but transportation is possible. So it really just depends. And if he is moved, that's something that the on-the-ground reports will probably clarify. It's like, this jail's here and that one's over there. But also then you give people the information that this person's being transported, and then it can become a security issue. Lisa, I'm so sorry as I'm reading through this. So glad you're here today. My dad passed away yesterday, and watching you is comforting. Lisa, lots of love to you during a time that's really, really hard to process with a loss of a father. I am so sorry. I know that the Law Nerds are going to send a ton of love your way as you walk through what's next. And I hope that soon you are able to remember all of the good things. So I'm glad you're here and that we can be a distraction. If you need distraction, your girl's got lots of content for you, hours and hours and hours of it. So thank you for sharing with the Law Nerds, and I'm sure they've already given you tons of love in the chat. Anne said, you did an excellent job last night. Well, thank you. It was my first appearance on Court TV. It's very exciting. Thank you for doing this, Emily. You're welcome. Does the prosecution have to disclose any evidence to the defense before this hearing? Yes, this is a fantastic question, Marianne. Yes, what the prosecution has, they need to give to the defense when they have it. So yes, the information pipeline in a criminal case kind of goes like this. What's mine is yours. Sometimes we redact some information out of a case. They might not need to redact much in a case like this. Sometimes some things are redacted and then they provide it later, like, hey, if you need the phone number for this witness, we will make contact with you. So the defense attorney isn't just cold calling people depending on the case. But yes, what's mine is yours in a criminal case. And there are lots of laws to make sure that that's the case. So when the defense attorney says they need time to go through all of it, this defense attorney is going to get, well, it's probably not boxes and boxes anymore, right? It's probably thumb drives on thumb drives. So Molly said all 3 female victims were in sororities. So again, this leads to what is this? What is the surviving roommate thinking of all of the possibilities that somebody could be in a house that people are in and out of that is not a horrible thing? And so I'm not surprised by that. Greek life is, depending on the campus, Greek life can be a huge part of trial of life. Sorry, as I'm reading other super chats to bring up. Rachel, XOXO, good to see you. Love that I've been around since 5K members and now watching all those early dreams for your channel come true. Thank you so much, Rachel. It's been wild. Did you see Cross Boss Vasquez got an NBC job? I did. We talked about it on Tuesday at the beginning of the show. Ashley, with the info we received today, will we get most of the information of what happens that night once the hearing happens in June? Not most. Some. We will get some. We will get some more information, but not most. So question, if the DNA comes back as a match, I think I just did that one. I forgot to uncheck it. I just read Bryan wants info on co-defendant. So far, we have not seen a charging document. We have not seen someone brought into court as a co-defendant. So we have not seen any of that. So if that happens, it will be big news, but we have not seen anyone else arrested. We have not seen another probable cause affidavit released. We have not seen a probable cause affidavit say, call him suspect number 2 or anything like that. We did see it say suspect vehicle number 1 with regard to the car, but that can regard not a separate person, but one person driving multiple vehicles. So that doesn't make me think there might be somebody else. So I will go take a look. I don't know. But again, if they suspected someone else, they might be saying, hey, not only do we want all the information you have on Bryan, but we want to know if you had any other suspects, or was he the only suspect at the beginning? So, excuse me. So let's see. Doesn't DUI guy do defense too? I'm sure that he does. It didn't come to mind, first of all, because he's a private attorney. I thought of public defenders first. So that's what came to mind to me first, was Natalie Lawyer Chick and Runkle of the Bailey, because 2 different countries, both public defense attorneys. Question, if the defendant pleads guilty, will there not be a trial and a judge decides his sentence? I hate this answer, but also it depends. Here's why it depends. Right now, this is a death penalty. Well, I don't want to say that. Right now, this is a potential death penalty case. The government hasn't decided if they are seeking life without parole. We know in the Murdaugh case, they are seeking life without parole, or the death penalty. So you could end up with a circumstance where the defendant says, I will plead guilty, but I want to have a sentencing trial, like we saw in the Nicholas Cruz case. That was just a sentencing trial, and a jury decided if it was going to be life without parole or death. So that is a possibility. It's a possibility that the defense attorney says to the judge, hey, Your Honor, if we plead to this, will you sentence him to life without parole, and then plead to the judge? It's possible that they work out a plea with the with the prosecution to take the death penalty off the table. All of those things are possible. So there could be an agreement with the prosecution and the defense that fixes the sentence at life without parole. There could be a trial to decide if it's life without parole or the death penalty, or the judge could decide. So there are three options if he wants to plead guilty. So that from my understanding, if a known suspect's DNA is uploaded into CODIS and it matches a cold case, alert goes to that department that case belongs to. That's my understanding as well, Angie, that those things kind of operate in the background, but people might proactively look if they have reason to. I don't know if they would have reason to. I just don't know if they would have reason to. Emily, if in this time they find additional crimes charges, can they add counts? And would there be a court hearing? There would need to be a new arraignment if they added counts in this jurisdiction to this defendant. If, like, with Harvey Weinstein, he was charged in New York, he was charged in California. If it's in a different jurisdiction, it wouldn't be added to this case. It would be a separate case, and then there would be extradition proceedings, and those would normally be stayed and follow along this case. So that can happen. I mean, that happened with R. Kelly. He had cases in multiple jurisdictions, and they waited one after the other. So that can happen. Let's see. Question: will there ever be a team of public defenders in bigger cases? Sometimes. Sometimes there will be multiple attorneys. So question: is every DA death penalty qualified? That varies office by office, and no, not every DA has the experience to be death penalty qualified. So experience is a big thing. Elena said, what if he is innocent? Then hopefully he will be acquitted, because we don't want to convict innocent people. Have you read the new 35? Are you going to read the new 35 article? I don't know what that's referring to, Carly. So let me know more specifically and we can go look. Let's see. I'm going to keep going through questions back and forth, and then we will move on to all of the other law we were going to talk about today. Question: does the defense get to depose all of the prosecution's witnesses? Tally girl, no. Depositions happen in civil cases, so they can interview, they can ask to interview, but no, they don't always get to interview all of the witnesses. They will get the police reports from when the police interviewed. If there's audio and video of that interview, they will get that. But sometimes the witnesses are like, I don't want to talk to the defense attorney. They do not get deposed like in a civil case where you sit down and are sworn and then there's a transcript. They are interviewed, and no, they don't always get to interview all of them. Sometimes the prosecution tries to arrange for it, and it just does not happen. So we'll see. Did you see reports, interviews that BK was a former heroin addict? No, and I'm not going to speculate on that. I didn't. But if that is, if there are alternative explanations for why the cell phone would be pinging in the area, then we would, why the cell phone was pinging in the area, then the defense will bring that forward. Candy's Crafts, were you death penalty qualified? I second chaired a case that could have been a death penalty case, but I did not go further with that. I did homicide cases, but then white collar cases, and then back surgeries, and then I retired. So no. Would I have been had I progressed? I don't know. I was really, really heavily leaning into white collar crimes, high tech crimes, and fraud cases. That's really the trajectory I wanted my career to take. There are lots of district attorneys that want to try homicide cases. There are not as many that like digging through computer files. So that was the direction I was leaning towards before I leaned out. So no, but I was a second chair on a homicide case that I thought should have been and wasn't. And the office decided that it wasn't. Well, that's fair. So I don't get to make those decisions. The DA that was the lead DA on the case didn't get to make those decisions either. But that's what it is. So that's now a life without parole. What is the title of the Court TV episode you're on? I was at the end of last night's closing arguments with Vinny. Question: because he's in jail, will he still be held in? It depends. That's a determination that they will make on the sheriffs overseeing that jail will make that determination. It's not something that has to happen. So it depends on all of the circumstances. I hate saying it depends, but it depends on all the circumstances. I just filmed something that will be on Hulu. I'll talk about it when I can. I'll tell you, I can't give deets, but I will when it's going to air. But if you haven't caught me on NBC, not NBC's, ABC's, the year 2022, I haven't gotten to see it either yet, but I'm on there. I think that's online now, and that's also on Hulu. So if you see the year, you'll see it. Elizabeth said I must have been on sub, so I haven't been able to comment. Are there any new information on the robbery charge? I haven't seen anything about a robbery charge. I'm curious to know what he took. I've only seen a burglary charge, and a burglary is breaking with the intent to commit the crime, and the crime being the homicides. So I didn't see anything about a robbery. I only saw a burglary charge for breaking in to commit the crimes, commit the homicides. So no new information. And yes, we are on subscribers mode. And yes, I have gotten a number of messages saying that YouTube has taken at liberty to unsubscribe people. I really hope they caught the guy and not a guy. I think we all do. Because if we go through all of this and it's like, wait a second, that's not good. So the DNA is going to be a hard one to explain. It's a hard one to explain. If it comes back to not him, then we're going to have a lot of questions. I went to U of Idaho, but my brother is a defense attorney, so I'm keeping an open mind. He won't get a fair trial in North Idaho. I think it'll be removed or moved. We'll see. We'll see. Will you look into the Delphi murders case at all? I have not had time to get up to speed. It's not something that I followed personally very closely. So the up to speed is a thing, especially with the it's not going to be before the Murdaugh trial. Will Bryan stay at the Idaho jail? Oh, we talked about that. Idaho doesn't have guilty. We talked about that. Thank you. We wait until you're competent to stand trial. And that makes sense to say not competent to stand trial and then competent to stand trial. But then somebody can end up in custody until they're competent. And if they're never competent for an undefined amount of time. Gadget Goddess GG, it's so good to see you. Lovely hair lady, long time no see. Too long. We've been busy. It's good to see you. Thank you for popping in. Thanks for the super chat, friend. It's so lovely to see you. If he pleads and takes death off the table, can the judge be like, oh, hell no? Okay, so in theory, a judge can reject a plea because they think it's inappropriate. In theory, that can happen. Do judges do that? Sometimes. They're like, no, I won't take this plea. It flouts the law and common sense. Is that realistic in this case between life without parole and death? Very unlikely, especially if that happens. The district attorney would have had conversations with the witnesses, with the surviving victim or the surviving roommates, with the victims' families, and would make a record that they are doing this in the interest of justice and why they are doing it. And generally, the court is not going to override that. If the defendant wants to spend life in prison without the possibility of parole and the prosecution is okay with it, generally a court is not going to stand in the way of that and say, no, put them on death row, which generally you're not going to see that. But in other cases, can the judge be like, hey, these are really serious crimes. You can't just do time served in probation? Yeah. But normally judges will ask more questions of the prosecutor. Why is this the right offer? What am I not seeing here? What do I not know? And sometimes that will go off the record and be like, Your Honor, this person is working closely with law enforcement as an informant. So what we need to do is play this case and keep moving on. That can happen too. So there's a lot of reasons, but judges will normally ask more questions first. Does defendant have access to media in jail? I don't know about this jail. Will he be able to view news stories about himself? I don't know. I don't know what he will have access to in this jail. I don't know if any of the on-site reporters have asked that or if anyone in the jurisdiction has talked about it. I don't know what at this jail he has access to, and I don't know what level he is kind of at within the jail to what he has access to. But he does have access to visits and people can tell him. Will you be covering anything on Darrell Brooks if his appeal goes through? He also has an attorney for appeal. I'm glad he has an attorney for appeal. I haven't looked at it yet. If there's anything that comes up that we really need to talk about that I can help shed a light on, I will. It's going to be a lot of a general appeal. When we see an appeal brief, will I take a look at it? Yes. But I also want to take a look at the Dog Toys versus Jack Daniels case too. There was a brief filed on that a day or two ago. Question, does the gag order apply to his attorney and even him? Yes. And anyone else on the defense team? Yes. As it does with police and DAs? Yes. Stefan said, Middle Tennessee here. Who decides the outcome of a preliminary hearing? The judge. The judge does. Thoughts on it being in June? It seems like a long time, but I also don't know if this defense attorney has serious trials backed up between now and then, and that's very possible. The DA didn't say, Your Honor, this is far too long. If all the attorneys in court are in agreement with it, I'm not one to say, why are they doing that? They will have their reasons. No one objected, so I trust that they have their reasons. This is a large case with a lot of information to go through. So those are my thoughts. If move forward, when's the next step? When it goes to preliminary hearing, then we've got like a week of preliminary hearing, then it'll get bound over. They've got 6 months to bring it to trial unless he waives time for trial, and then we will see it go to trial, but it can also plea anytime in there as well. So if they admit to a lawyer, can the lawyer then argue innocence? Lawyers generally don't argue that someone's innocent. I've never seen a lawyer do that. In fact, I've seen lawyers argue that there is doubt. And yes, they can still argue that there's doubt because it's not the defendant's job in the criminal justice system. Ding, ding. It is not up to the defendant to prove that they're innocent. It is up to the prosecution to prove that they did it beyond a reasonable doubt. And the defense attorney can say there's doubt here, and this is why there's doubt. So if there's not enough evidence to prove it beyond a reasonable doubt, even if the defense attorney knows they did it, the defense attorney has an ethical obligation to their client. Lawyers get a bad rep, but are they allowed to blatantly lie? I don't see it as a lie if they're saying the prosecution hasn't proved their case. It's different. They're not arguing this person didn't do it beyond a, It's this prosecution hasn't proven it. What about this? What about that? And putting that doubt into the minds of the jury. And that is their job. And that is their ethical obligation. They can't lie to the court. But again, arguing that the prosecution hasn't proved their case is not lying. So that's what it is. Let's see. Question. Is there a way to look up the defense attorney's past cases? I haven't done that. I'm sure people will. I just haven't had time. But some people will look to media reports and things like that to see what else this attorney has been involved in. Question. If the DNA on the sheath came back as not BK and the prosecutor no longer felt they had enough evidence, do they still go through with the trial? No. If a prosecutor felt that they could not prove the case beyond a reasonable doubt, or they think that this defendant is not it, it is their obligation to dismiss the case and continue pursuing other possible suspects. Unless they think like, hey, this DNA, there's an explanation. This DNA came back to one of the roommates, so maybe this isn't the murder weapon. It really depends. But if taking it out of this case, if a prosecutor is looking at a case and like, we don't have enough evidence to prove it beyond a reasonable doubt, they should dismiss the case. That is the appropriate and ethical thing to do. Do all prosecutors do that? That's why you have defense attorneys, to be like, yo, what the fuck? Your Honor, they don't have enough to take this to trial. And they shouldn't. Look, here's the thing. There are enough crimes that are committed that you don't need to try to get somebody that you can't get. Even if you think they did it, there are plenty of cases where I'm like, yeah, I'm pretty sure they did that. I can't prove they did that, so this case is getting dismissed. There are plenty of cases in the system. Our criminal justice system is active and full. So prosecutors don't need to waste their time with cases that they can't prove. So anyway, that question, and then we're going to move on to some, I'm going to wrap up a few more questions and then we'll move on to some of the Girardi topics real quick. And then we'll get to Girardi questions because there's only so much we can talk through. I think we've kind of covered stuff well. Question, studying to be a teacher here, advice on how to teach a U and the law class to high school students. Make it relate to them and use the storytelling. Use storytelling examples. Use, if you're talking about intellectual property, use something that's fun. If you're talking about criminal cases, use something that's interested to them. Relate it through story. Don't just try to be like, okay, so this is the Fourth Amendment. Just give them scenarios. I think it's a great way to learn is through example. Or break down music and be like, let's spot all the crimes that happen in this song. Might I suggest Carrie Underwood before he cheats? There's a plethora of crimes in that one. Country music will give you a lot. Well, rap too, but country music will give you a lot of music where there are crimes delineated. The Thunder Rolls also comes to mind. Oh, Papa Love Mama. I don't know why I'm in a Garth Brooks kind of a mood this morning, but it's a vibe. Papa Loves Mama. Also crimes. Lots of different crimes. So spot the crimes in music, or let them pick the music, and then y'all spot them together. Great way. Like, oh, that's not legal. Great way to do it. Make it relevant. And that will help. So let's see. Aurora, I answered this earlier in the show, so it is there. I talked about it. Question: have you seen the Florida case? Florida? I don't know. I'm always wrong in pronouncing Florida. That's what we're going with. Yes, I have seen it. I have not been covering it, but it is streaming live. I know. Only one me in so many cases, but yes, I've been keeping a side eye to it. So, why was the Kohberger's lawyer in Pennsylvania allowed to talk about Kohberger? I haven't seen the Kohberger's lawyer. All right, y'all are gonna make me Google. We might not. We're gonna get to Girardi, I promise. I spent most of my day yesterday filming. So if something happened yesterday, we saw the thing today, but not much else. Let's see. I have to look at what was said to look at whether it falls under the gag order. So this was 2 hours ago. Let's look at Newsweek. All right, we've gotten a lot of questions. Let's just get to it. I know I don't pronounce Florida well. It's spelled Florida. Look. I'm basic. No, I actually know. Look, welcome to my house is, I think, probably the thing that comes to mind first. All right, we're going to pull this up. What shade of Gerard lip gloss are you wearing? Pink frosting. Saw you in the Britney Spears documentary. Great job. Oh, I haven't seen that yet. I forgot that was out. I need to go look. I forgot that was out. They don't always tell me. I film things and then I don't always know when they're released. It might have come out right as I was leaving on vacation. I need to go look. So, let's go see. Wait, is it spelled like Florida on purpose? I think so. He uses the state in a lot of his different things. I think so. First name Flo, last name Rita. Yes. Absolutely. Stage first name Flo, last name Rita. So, all right, let's go to this Newsweek article and take a look. There's also a News Nation video on that from 15 hours ago. Look, as I say, I was out of pocket most of the day yesterday. All right, I'm going to swoop. I guess we're going to talk about the gag order. We're going to talk about this news story, and then we're going to talk about the gag order. The law nerds have demanded it, and that's what we're talking about. All right, let's go take a look at this Newsweek story. Oh, that's a lot of information on a screen that I don't need. Bryan Kohberger's ex-lawyer confident there's more evidence in Idaho killings. I'm also confident there's more evidence because a probable cause declaration is not everything. We might have to watch this news report. Okay, y'all, let's take a look at what the article says, and then maybe we'll just go to if this is a News Nation report, just go to the News Nation report. Because it looks like it is a News Nation report. We'll just go to the source. Bryan Kohberger's former attorney, Jason Labar, recently said that the prosecution in Idaho will likely provide more evidence in the quadruple homicide case. Well, that could also just be speculation, but no shit. They'll provide more evidence. There's more evidence than in the probable cause declaration. On Wednesday night, Labar, who represented Kohberger in Pennsylvania for his extradition to Idaho, spoke with Bryan Entin of News Nation Now about the recently released probable cause affidavit and the evidence that investigators used for Kohberger's arrest on December 30th. We're going to go watch that report. Kohberger was charged with 4 counts of first degree. We know that. Labar said, while there are several holes in the affidavit, he expects the prosecution to provide further evidence in upcoming hearings for the holes to grow smaller. That's a bold statement. All right, let's go to the News Nation report. Let's just watch it together and have a chat. Let's have a chat about Bryan Entin's conversation. Y'all asked a lot in the chat, so we're doing it. Oh, we're going to go to the video interview. We're just going. Baby Gator, yes, it's called Discovery. I didn't mean to hit both of those at once, but I really like the way that that worked. I'm not mad about it. They're not going to show their whole, yeah, the probable cause affidavit is just that. Bryan Entin is fantastic. He is. I think he's great. The ex-lawyer didn't reveal much. No, what he said was, so there's probably more. So we'll take a look. Let's just take a look. Here's News Nation on
Bryan,
YouTube.
you have just
This
spoken.
is 5 minutes long. We have plenty of time to give commentary on people giving commentary on Banfield. Let's just do that. That's what we do. We're a commentary channel. Not to mention, I can see why so many streamers just do commentary on video. It's so much easier than having to pull all the documents off a Pacer. All right. When will they announce whether they are seeking life versus the death penalty? They have a while to do that. Pam, any news on Britney Spears? I have not seen any reports, and none of the documents were updated in the court system from yesterday's hearing. So we will probably cover that on Tuesday, because I will probably be able to gather the information before that. All right. See what Bryan Entin has to say. How much do you have to? Here's what I want to know. If I interview Bryan Entin ever one day, maybe it'll happen. How much do you have to pack when you go to Idaho? Do you know how long you're going to be there? Do they tell you you're going to be there for months? Do you plan on being there a few weeks? Are you sending out laundry at the hotel? How does this all work? How do you wrap your head around the fact that you're like, well, we're going to go cover this story. Who knows how long we're going to be there? So, commentary on commentary. We're just doing that. Yeah, we're just going to the source. So let's see.
With that public defender who.
Here, I should start at the beginning. Let's see. Do we have closed captions? Yes, let's turn those on. There we go. All right.
And Bryan, you have just spoken with that public defender who represented Kohberger immediately after his arrest. What have you learned?
This is why I could never be a reporter, because in my brain, this is how my brain works. Hey, there's a gag order. Don't ask. Where if I was, reporters have to necessarily ask things that they think they can't get the answers to. They have to ask and ask and ask and be like, look, if you don't ask, you don't get. So I appreciate the journalists and reporters who are like, no, I'm going to ask. If they say no, they say no. That's it. Because I wouldn't ask. I would assume the no. This is why I'm a legal analyst. I just want to cover documents. I don't want to have to call people up and be like, could you give me a comment? That makes me so uncomfortable. Okay, let's keep going.
Yeah, this was interesting, Ashley, because last time we saw the public defender in Pennsylvania, Jason Labar, he was with Kohberger in court. I was in the courtroom, but he had not seen the 18-page probable cause. So
the defense attorney in Pennsylvania arguing the extraditions didn't have the probable cause affidavit because in Idaho, they are not unsealing the probable cause affidavit until the defendant is served with it when they land in Idaho. So I'm not surprised by that. We're going to look at the gag order after this so I can give my thoughts.
now I asked him what he thought about it, and he says he thinks there are holes in the probable cause. He is questioning the phone pings.
He has questions.
He
I do
says
too.
that those pings are not specific GPS coordinates, and he says
That's
the
fact.
defense can have a field day with those pings, calling them out. He is also questioning the description of Kohberger from the surviving roommate.
So talking about the pings, it's very interesting because what we don't know about the cell phone pings is how broad of a radius that is. Like, look, I don't want anyone pinging my cell phone near the fast food that I might frequent. Look, you don't need to know how often I might be at a particular Taco Bell. I shouldn't be. And in the new year, have not been once. I'm just saying that. Taco Bell is delicious, but it is not supposed to be a regular dinner for me. That does not work for me. But also, what if there was a house 4 doors down from the Taco Bell I always go to? If something like this happened, I would be like, I always go to that Taco Bell. I'm at the Taco Bell. Pull up my credit card receipts. Sadly, that's where I am. It's nothing. Look, man, they brought back the Mexican pizza. It's just a coincidence. Stop it. Stop it. They tried to make a grilled cheese taco thing. Look, sometimes we have to try it. So there could be, depending on what's in the area. And of course, this street is a cul-de-sac. That might not be this street, but we never know how large that triangulated radius is. But now that they know more information and have more information, we might get more. So let us continue on. I'm just saying there are other explanations within that cell phone radius. And this is where a defense attorney gets to work on what is doubt. And this is why they need time. They need to know the triangulation. Absolutely nacho fries. Sorry, Chad. I think I make you hungry every single stream. It's just true. It's just true. It's just true. All right, let's keep going.
That description that she says
I'm gonna make this louder. Hold on.
was, you know,
Let me see if that's good enough.
the man who is about 6 feet tall and the bushy eyebrows, he says it's just not specific enough. And then I asked him about the statement. Remember that statement that he initially put out right after Kohberger was arrested? Very interesting. Kohberger had a lot to do with that statement. Listen to what he told me.
Okay, let's listen.
The statement that you released from
Recorded phone call.
Kohberger, where he, you know, said that he was innocent, essentially. Did you write the statement with him? I don't know if you can share how that statement came about.
The statement came about Friday night when I talked to him, and then I went out to the jail at 5 o'clock.
Just to answer the chat real quick, this is not his current lawyer. His current lawyer is very clearly covered by the gag order. I'm questioning whether this this attorney is covered by the gag order. We're going to look at the gag order together after this. I haven't, Rotten Ralph, sorry to interject. Rotten Ralph said, I haven't eaten Taco Bell since I quit my shift manager job there at 18. Dr. Baker has a similar feeling about KFC. Once he worked there, he will no longer eat there. He's like, I spent too much time there. So I get it.
I know there was a lot of people, a lot of news media outlet at the jail at that time. But I knew it was dark out, so I could essentially sneak in under the cover of dark and be able to talk to him without anyone knowing that I was actually there.
Such a defense attorney. I swooped in under the cover of darkness, like Batman. Is that something non-lawyers say, under the cover of darkness? Is this just a lawyer thing?
And I spoke to him for about an hour. I let him know about the statement. That I wanted to get a statement out there because
Before the gag order?
With all of the news media, I knew there was going to obviously be issues as far as him receiving potentially a fair trial. People jumping to conclusions, you know, automatically you worry about the presumption of innocence and
that, JP, that's what we're going through right now, is Bryan Entin's phone call with this defense attorney who is talking a lot. Which is interesting because there's still a level of attorney-client privilege. Like, did that get, like, does this defendant, because even though he's no longer the active attorney for this defendant, there is still a duty owed to Bryan Kohberger because he had represented him. I have a lot of questions about how we're saying all this. Let me back it up real quick because I was reading that and I wanted to hear a little bit more. Sorry, we're going backwards. Not only do I repeat myself when I talk, but I repeat myself when I watch things.
obviously be issues as far as him receiving potentially a fair trial. People jumping to conclusions, you know, automatically you worry about the presumption of innocence and the integrity of the criminal justice system. So I said, Bryan, is it okay if we get a statement out? And that's when he brought up the eager to be exonerated language. And obviously that was included in the statement.
So that was him. That was him who wanted to put that in.
The eager to be exonerated was the language he used.
Interesting.
We put it in the statement. But obviously when I talked to him about the eager to be exonerated, to me, when we talked about it, it was more or less he was asserting innocence, but that's the language he used.
It makes me uncomfortable. I'm going to have to go watch Peter's coverage of this, but this makes me a bit uncomfortable. Why? Because conversations between a defense attorney and a defendant are privileged. The only person that can waive that privilege to talk about those conversations is the defendant. Has that been done here? I have to assume it has. This makes me uncomfortable. Targos went through his whole interview this morning in its entirety. He did say a lot. All right, we'll go look for it. I mean, this is what we're talking about today. We're I will pull up the American Express Girardi stuff at the very end, but y'all have me invested. So, and let's do this and then we'll go. Is this a Waldman style agency? No, this is a appointed defense attorney. This is not a hired personal representation for a celebrity. This is an appointed defense attorney. I'm uncomfortable. Because he didn't make clear, I have cleared it with Kohberger that I can have this conversation with you. I need more. I'm uncomfortable. Sorry. That was me. Oh,
So very
asserting innocence.
I clipped it. I'll go look to Twitter and see if the whole video is there and then pull it up.
Talked to him about the eager to be exonerated. To me, when we talked about it, it was more.
When we talked about it, this is him giving a reporter a relaying of a conversation he had with his client. This makes me very uncomfortable. Margaret said Peter asked the same questions you are. He had the same concerns. Good. We're all on the same page. This makes me uncomfortable. I'm not going to assume the worst. It makes me uncomfortable that this attorney did not say this has been cleared. And maybe he did and it's cut out. This is a news story. We'll go look and see if we have the full conversation. Because he still owes a duty to his clients.
Less he was asserting innocence, but that's the language he used.
That's the language.
So very interesting, Ashley, that Bryan Kohberger, is the one who came up with those words.
I keep pausing. Anytime you have a lawyer saying, my client said this, we have a big issue. You have to know why the lawyer is saying it, and that has to be waived by the client. Bryan Entin has it on his Twitter. It's in a couple parts. We're going to Twitter next. I want to see what Bryan Entin says about it on Banfield, and then we'll go to Bryan Entin's Twitter. Chad, I see you asking for code red. We might be in a code red situation. I have questions.
Words, eager to be exonerated. Mr. Labar also said he does not believe that Kohberger can get a fair trial here in Moscow, Idaho. He believes that this trial will likely eventually be moved to another jurisdiction.
Well, I think Mr. Labar, it brings up a very good point.
I think Mr. Labar is talking about what his client told him.
This is the kind of thing we have to deal with every time there's a high-profile crime and a high-profile defendant.
The internet cuts against this, though, not to completely interrupt and I'm sorry, that's an uncharitable freeze. I'll hold my thoughts until we get to a better pause. I hate it. I hate an uncharitable freeze.
Every time we've covered a Casey Anthony or an O.J. Simpson or a Jodi Arias, there's the issue of how to pick a jury where everybody knows everything about the case. And by the way, you can, because they all had fair juries. They all found juries.
Here's the thing. We're getting to a point where the internet is so ever present. There's an argument to be had of, okay, but expand the jury pool. Okay, bring more people in from other parts of Idaho. You can't bring them in from Washington, other parts of Idaho. Expand the radius around the courthouse you can bring people in from. But if you move it to another county, those people still have the internet. It's not like this is a local news story that is blown up in just this community, and it's on the front page of every newspaper in just this community. And if you go 2 counties over, no one's ever heard of any of this people. The internet has obliterated that. So why would it be different anywhere else? Because the internet exists. And so there's an argument to say, leave it here. The internet exists and this community has an interest. And there's always going to be people who haven't gone on to the internet. We saw that in Depp v. Heard. There are people who are like, I have not been following this story. I don't care. Will you find people if this goes to trial here? Maybe. So I thought the OJ trial shouldn't have been moved out of Santa Monica to downtown, but they moved it. They said he can't get a fair trial here. Okay, fine. So they moved it. I have thoughts.
in those cases. So it will be difficult, granted. So I wanted to ask you a little bit about this hearing tomorrow. It's so hard, Bryan, to find out any information with the gag order.
We already did the hearing tomorrow. With the gag order, let's go look at the language of the gag order first and then go to the rest of this interview. I don't like this at all. I don't like this at all. I don't like this at all. All right, let's pull up the gag order. This makes me very uncomfortable. All right, here's the non-dissemination order. Let's pull this up. I'm gonna have to like scoot forward to get in my seat so I can read it. Here's the non-dissemination order. It is hereby ordered that the parties in the above titled action, including investigators, law enforcement personnel, attorneys, and agents of the prosecuting attorney or defense attorney. So agents. So like somebody who's working with the defense or prosecution are prohibited from making extrajudicial statements. That's an extrajudicial statement. Written or oral, it's oral. Things the internet can clip later. Concerning this case, I've said worse, other than a quotation from or referencing to, without comment, the public records of this case. I think the former attorney who still owes a duty might be covered by this, but I think that attorney would also argue, I'm not in Idaho. I have not been specifically gagged because I am not in Idaho. If I'm the defense attorney in Pennsylvania, I am exercising my right to shut the fuck up and not say anything. I am not making a statement at all. That's me. I'm definitely not making this statement. I see the chat saying hi to Rob. I didn't see where Rob popped in, but I see all the hi Robs. So hi, Rob. Can't wait to see what Rob has to say about this. I don't like this. Why are you making statements? You still owe this client. This is not a PR thing. You still make this client, you still owe this client a duty. Rob, have you seen this interview? He's talking about things as the client told him. That's privileged. Stop. Oh. He'd have to be subject to the jurisdiction of the court, which is hard to argue, but I wouldn't be making it either. And I don't know if the court's going to do anything about it other than be like, yo, stop. Let's go to Twitter. I think I'm going to grant code red. Let's go to Twitter first. Every time we go to Twitter, I feel like it needs to be code red. And this is the thing. When I was recording all day yesterday, I didn't see this all go down. I did see that the internet was talking about Shannon Bedore potentially breaking up with her boyfriend. I saw the internet talking about that. That's what I saw. And then I didn't even get to finish Real Housewives. Here's the fuckery. Look, since it's now a meme, The Matrix is real, and it got me last night. Why? Because Hulu wouldn't let me finish Real Housewives of Salt Lake City last night. And I tried on 3 different TVs in my phone. 2 different TVs in my phone. I was so annoyed. Every time it got to like the Bad Mormon book cover launch party and then cut out every single time. The Matrix is real. Oh, I hate all of this. My full conversation with Bryan Kohberger's Pennsylvania public defender, Jason LeBar, tonight. He says he thought the probable cause affidavit was a strong circumstantial case that had holes. It's a probable cause affidavit. Why are you talking? Why are you talking? Oh no! I broke the ear off of it. Oh my God. Emily, you're not allowed to stream. I saw it go flying. I can fix that. We can make it better than before. We can make it better than before. I'm sorry, goat. Look, he's got character. We only need the one ear. I broke my pen versus during Dep v. Heard. We're going to DEFCON Red. We've broken our goat. The ears have gone flying. I don't know what this defense attorney is doing. I've broken my goat. We have to go to DEFCON Red. I don't know what else to do. We're going to DEFCON Red if you are flash sensitive. This is flashy. It will stop flashing when the music ends. So just be mindful. Sorry, I forgot I had gained up the sound for the audio from that last video. So it also is probably scaring the shit out of all of your pets. Apologies. I've broken my goat. Damn it. I'll fix it. It'll be better than before. Maybe we'll fix it with gold. It'll be a whole new thing. Rob knows my reference. It looks like I can fix it. It looks like it can't be fixed. I'm sorry, screaming goat. You might get replaced by a yodeling pickle now. Okay, let's see what Bryan Entin has to say. Let's make this as loud as we can make it. Broken gag orders, broken goats. Oh my God, the sky just got so dark here in Tennessee. The sky is angry. Am I under a weather watch? I don't think so. It's supposed to snow tomorrow. It's like 60 today. That's probably not good. All right, let's keep going. We'll talk about weather later. The sky is like, you can tell my lighting is changing. We're going to be in DEF CON Death Star soon. All right, let's keep going. Here's the thing. No shade to Bryan Entin. I appreciate journalists and reporters doing their job. Ask the questions. Ask the questions that you don't think you can get an answer to. The person who shouldn't be answering the questions is the one responsible for not answering the questions.
In Pennsylvania, what was your first impression?
When I met Bryan Friday night,
The focus is off,
he was
Bryan.
arrested.
We need to not focus.
Bryan was very cordial. He was calm. He was aware of what was going on. He was shocked by the arrest.
How is this not privileged? Somebody explain to me how this is not privileged, because I can't wrap my fucking head around how this is not privileged. Oh my God. Chat. Vincent Van Goat. We're renaming the goat. We're not fixing the ear. Chat is Bay. You guys are the best. Severe thunderstorms. All right, I get it. Vincent Van Goat. Vincent Van Goat. I'm keeping it. Okay, the volume is super low. Let me go to my, I put a volume enhancer on my player during the last trial. So we're going to bump this up, and then we'll see if we need to bump it up even more. So let's try again. I'm already outraged and confused. A 20-minute interview giving too much information. Well, we're doing it now. Here we are. Hold on. Let's swoop to Bryan Entin's interview. I'm baffled. The chat kept saying, but the defense attorney, and I'm like, what are you talking about? And then the chat was like, girl, no, girl, this. And I'm like, oh yes, this is why I live stream, because the chat is the best. And now I'm deeply invested in how the fuck this is happening.
Mr. Labar, when you first met Bryan Kohberger in Pennsylvania, what was your first impression?
When I met Bryan Friday night, the night he was arrested, Bryan was very cordial. He was calm. He was aware.
Him being cordial is you still relaying your conversations with a client, even though it's his demeanor. All of you asking if this can hurt the case. I'm gonna listen to the whole thing, and then we're gonna go from there. Vincent Van Goat might have to be merch. Oh, there we get the thunder rumble, and that's why we're thinking Garth Brooks today. All right, let's keep going.
Aware of what was going on. He was shocked by the arrest, but he certainly was.
Just every time I make a face, just go, privilege, but privilege. He was shocked by the arrest. The only way a defense attorney knows that he's shocked by the arrest is because he fucking said that to you. You still owe him a duty. You still owe him privilege. Attorney-client privilege can only be waived by the client. Has he waived that privilege? Because I don't even know if he's waived that privilege. This makes me so uncomfortable. This makes me so uncomfortable. How much you want to bet the prosecutor plays this to demonstrate his mental impression upon arrest? I mean, could. As a retired therapist, there's no way this wasn't breaking confidentiality. I don't see how it's not. Am I missing something? My gut is this is a problem for this attorney. Can it hurt this case? I want to hear everything he says. Can it hurt this defendant? This information shouldn't be out there. The only information that should be out there is when he said to the defendant, I want to make a statement. I want this included. That should have been the only statement. what the defendant agreed to. Everything else is privileged. If you can't trust that your lawyer is not going to go around and tell everybody what you said, who the fuck can you trust? Your lawyer owes you a duty. I mean, they also owe you a duty not to steal your fucking money. Oh, I also can't wait for Natalie Lawyer Chick to break this down. I can't wait for Natalie Lawyer Chick to break this down. I can't wait. How are you making these comments right now? And how do you not see the problem? Again, no shade to Bryan Entin. He's doing his job is to ask the questions. The lawyer's job is to know what he can and can't say. And this sure feels like maybe can't. But we're the curious public, and we're going to lean right in and find out.
He was easy to talk to, very intelligent.
He was easy to talk to.
I really had no issues talking to him.
Very intelligent.
Did you?
So for all of you that asked about a potential NGI, even though it doesn't exist, thank you to the chat for letting me know that that's what Andrea Burkhart has discovered in her fulsome research. Am I going to say that more until Hoeg's back? Yes, I am. It's going on the bingo card. But this also shows that he was completely cognizant, linear, intelligent. So there's no argue that he was just discombobulated. He was surprised by the arrest, but he was linear. He was great. All of this feels privileged.
Did you talk about the details of the case?
When I walked into the room and I shook Bryan's hand, before Bryan could even, I think, say hello, I basically cut him off and said, Bryan, I'm merely your attorney for your extradition. I don't want to know any of the details about the actual facts or circumstances of the case or the allegations.
Don't tell me anything, because I'm going to go tell the news.
That's for your attorney once you get to Idaho to talk about. I'm simply here to talk about the extradition and the elements surrounding the extradition proceedings.
Did you get
what he told his client should also be privileged? Oh, flashy. Y'all, if the internet goes out, I apologize and I'll be back, but we got some weather coming through. Him saying, I told my client this, makes me deeply uncomfortable. The answer should have been, I'm sorry, Bryan, I can't answer that. I can talk about the statement that we've previously released. I can't give any more details. I hate this.
get the sense, because he was getting his PhD in criminology and had his master's, that he had a good understanding of the process more so than like a regular client you may have?
Well, you have to understand the clients that I normally have don't even have a high school education, let alone a degree from a college. So it was much easier to talk to him about how things would proceed and how the hearing would go than my usual clients being a public defender. But yeah, it was pretty easy to talk to him. He was aware. He did ask questions about how things would go. He wasn't fully aware.
That's things he said to you
behind the hearing and what would be expected. But I certainly know after explaining to him, he understood.
Why did you decide to release the information about the Indiana police stops? Because I think we got it from you first that those stops had happened.
It's going to get very loud around here, but it looks like I am not covered specifically by this severe thunderstorm warning. Sorry, I'm looking at, yeah, it looks like I am not specifically covered. I'm right outside of the box of the severe thunderstorm warning. Great. Nashville severe weather is my favorite resource on Twitter for weather. So there's a weather update from Emily. Yes, I moved from California to Middle Tennessee. Yes, I am still thrilled by weather. Yes, I enjoy weather. Yes, we have watched the sky get very dark today, and now we're rainy, flashy, and loud. So let's continue.
I think it is accurate. It came from me. It really just came in conversation with Bryan and his father.
Conversation with the defendant, the accused, and his father. So y'all were talking together? Great.
I was aware that I was trying to make sure that they knew the date that they came back from Pullman, just to make sure that it establishes that he would have been in and around the area at the time of the incident. Never contested. He had been in Washington State.
I'm going to go back a little bit because I'm interested in this part. And I was talking and I'm like, my brain is trying to process through rage.
With Bryan and his father.
I need to go back a little bit.
I think we got it from you first that those stops had happened.
I think it is accurate. It came from me. It really just came in conversation with Bryan and his father. I was aware that I was trying to make sure that they knew the date that they came back from Pullman.
I was trying to make sure that they knew the date they came back from Pullman. Were you asking them or were you telling them? And why isn't all of this privileged?
Just to make sure that it establishes that he would have been in and around the area at the time of the incident. Never contested. He had been in Washington State University up until mid-December. But when I talked to his father, he had talked about being stopped.
The father statement's not privileged. The father statement's not privileged.
On the way home, twice by Indiana State troopers, twice back to back. So it's something his father had told the FBI or Idaho State Police or Pennsylvania State Police, whoever interviewed Michael here in Pennsylvania. He had already told that to authorities, so I felt comfortable.
So the father was already interviewed by authorities. This is all information we can learn. This is all okay with me. The father was interviewed by authorities. The father shared with me because the father, he doesn't owe a duty to. The father's the father. The father is chatty. The father in the traffic stops is like, well, no, we're not just going to get lunch. We're driving from here to there because the father didn't think anything was wrong. It shows me that the father didn't think anything was wrong during those traffic stops. Or Bryan, it seemed to me, was trying to be a little more narrowly tailored. So to be fair, the son's statements to his attorney in the presence of the father, also not privileged. I'm not clear that they were all present during this conversation, or he did say in conversation with Bryan and his father. I'm not sure of how much of this was with Bryan and his father, though. This is all making me tremendously uncomfortable, Rob. But yes, you raise an excellent point if the father's there. Isn't he also the father's lawyer? No. This is the defense attorney that was assigned to Bryan Kohberger in Pennsylvania to deal only with the extradition to Idaho. So no, this is not also his father's lawyer. This is not a hired family lawyer. This is a public defender or defense attorney appointed by the state to represent this defendant for the purpose of extradition only. But even when you are done with your representation of a client, you still owe them a duty. The privilege still extends, and the only person that can waive it is the client.
Comfortable saying it as part of one of the interviews that I had done, that he had been stopped, because I felt a little suspicious about it, that he may have been followed from Washington State, although I think that has been debunked to some degree.
So when you were representing him in Pennsylvania, and I saw you in court, obviously you had limited information. Then when we got here to Idaho, the probable cause was released. What was your reaction? I'm assuming you've read the 18 pages. What was your reaction to all of that evidence?
I immediately was given the affidavit of probable cause when it was released, if I recall correctly.
Because you were still connected in a way to this case. You were given the probable cause affidavit after he had already gone back to Idaho.
I'll restate this then, Bryan, so it's clear.
Yes, please.
Just trying to remember who actually gave it to me the second it came out. So I immediately read the affidavit of probable cause. I believe a news media outlet that I had been in touch with sent it to me the second it was released.
The news sent it to him and was like, can you comment on this? The news will do that. I always find it very helpful when people are like, hey, this just happened. Can you comment? I was like, let me read it, and I will. But I'm not involved in any of these cases. I just do this.
I read over it 4 times, I think, until I soaked it all in. And obviously what I had read, I now had an understanding of the evidence against him, because I had been working in the blind the entire time, because I didn't have access to the affidavit of probable cause or know anything about the facts and evidence that they had against them to verify the arrest.
What was your reaction, though? Were you surprised by the amount of evidence? Did you think it was solid?
I stated a couple times to other...
Hey, Bryan, I appreciate that question. I've read it, but I'm not going to go ahead and comment on whether I think the case against my former client is strong or not. not only is there a gag order, but sure makes me uncomfortable. I want my clients to know that they can trust their lawyer not to talk to the news media about them.
Individuals and other outlets that, the way I would classify it, based upon my experience doing this for 17 years, read
Me too.
about 25 homicide affidavits of probable cause at least, and represented several homicides, capital homicides through trial. I wasn't.
He has the experience to know.
Too surprised. I thought it was a strong circumstantial case that had holes and that could be exposed by a competent, good defense attorney like Attorney Taylor, I felt.
What would you say the biggest holes are?
I have been talking about like the biggest evidence and going step by step, because they are going to, defense is going to attack each part of the evidence separately, really, because the Commonwealth's case is really based upon circumstantial evidence.
I don't think Idaho is a Commonwealth, but also I forgive a Pennsylvania attorney for saying the Commonwealth, because when they go to court against the prosecutors, it's not the state, it's the Commonwealth. Just like, look, I didn't know that if I had moved to Canada, that I would not only have ready access to all dress trips, but I would get to be the Crown prosecution. And you show up and it's like, for the Crown. Like, nobody tells you this when you're in law school. It's like, oh, if you become a DA in California, it's like, excuse me, Emily D. Baker for the state. But if I go to Canada, it would be for the Crown. That is a whole nother level of getting to say cool shit. But in Pennsylvania, it's going to be for the Commonwealth, not for the state. Idaho's a state, not a Commonwealth. We're going to let this dude speak, and I'm going to try to not cough anymore.
There's no direct evidence against Bryan. So their case is in the whole, whereas defense will be attacking each piece of evidence individually, I believe. At least that would be my trial strategy. So if you talk about the sheath being found in the room, you have DNA recovered from the...
This is my trial strategy based on only seeing a probable cause affidavit. But yes, if you've got a puzzle, you attack each of the pieces.
The button of the closure of the sheath. What you can say about that is it's transferred DNA, it's touch DNA. That DNA could be on there. Nobody knows how long, if undisturbed. Certainly it could be a year, it could be longer. Experts going to testify that obviously it was placed on there because Bryan touched it, but they can't say when he touched it. Now, there could be additional evidence that comes out about that sheath. One being, it could be actual DNA on it. The state police executed a search warrant of Bryan's blood when they were here in Pennsylvania. And we don't know if that's additional evidence that may come out if there's unidentified blood on the sheath.
I had been hearing people talking about whether or not there was blood in addition to the DNA on the sheath. All right, well, we know they've collected Bryan Kohberger's DNA and blood. There's probably a reason they collected his blood. I imagine this crime scene had a lot of blood. Woo!
In addition to the sheath, the knife itself obviously not found. But we don't have the results of the autopsy, so we don't know if it's consistent with a straight edge.
He hasn't seen it. Seen the results of the
That would
autopsy.
change my feelings about the affidavit of probable cause too.
What I will say is the complaint that was read in court indicates that the homicides were perpetrated by stabbing. So that, and the probable cause affidavit does talk about that the wounds seem to be caused by a straight-edged instrumentality. Oh, that was the end of this one. Okay, good. It looks like I stopped at a good place. All of this makes me uncomfortable. All right, part 2.
Man's footprint in the affidavit of probable cause, they don't match that with Bryan. I would say that I reviewed I think it's at least one video of a previous encounter of the police at the home of the victims, where the individual who answers the door is actually in a pair of Vans. I know I saw that, and I pointed that out last time I saw it, because that's what was interesting about that.
Who did you point out?
Probable cause. Now, again, it could come back that Bryan has a pair of Vans.
It could come back that the people that live at the house have smaller feet. It could come back that a lot of people were in the house in and out, and the defense will argue that. Look, these are college kids. There's a lot of roommates. People wear Vans. I mean,
that could possibly match that. You talk about the vehicle. The vehicle's interesting because, I mean, there is no direct evidence that it's Bryan's vehicle.
him being stopped driving it and it being registered for him being stopped driving at the exact vehicle on multiple occasions, and it being registered to him, and it being parked at his residence, and it being parked at his university is direct evidence to me. I don't know how you get more direct evidence. Is he saying that that's all circumstantial and the only thing direct is if you have the actual like pink slip in hand, which they might now because now they have the vehicle.
They used the cell phone.
Yes, they were also his license plates.
Tower pings to link the vehicle to its whereabouts the night close to the home.
I disagree.
They use that to track it allegedly.
I disagree with that interpretation. But again, all attorneys are going to interpret things differently. I disagree with that interpretation. I think the pings align things, but they also use those previous traffic stops to tie him to the vehicle. They also use video to tie the vehicle's path. So it's not just the pings.
But there's really no evidence that it's still Bryan's vehicle. You have the license plate on the back, not on the front.
My guy. Since he's playing defense attorney on TV, I'll just play prosecutor on TV. There's no evidence that this is still his vehicle, except for the video of him driving it after the murders to Pennsylvania, where he is then arrested. He's literally caught in 4K. I mean, it's not 4K because it's body cam footage, and the body cam footage isn't actually 4K. I get it. Asterisk, he's caught in 4K. That's probably more like less than 1080p, but he's on video driving the vehicle. So if the defense goes to trial and is like, there's no evidence that this vehicle's still his, it's like, why is he driving it out of state? He changed the license plates on it after the homicides. He's still exhibiting control over the vehicle by re-registering it in Washington from Pennsylvania. Let's keep going. I disagree. But also, it's nice to hear what somebody else wants to say because I didn't know that needed to be explained. So, yeah, let's keep
understand
going.
that, but I'm sure it's still not the only white Hyundai Elantra 2011 to 2016 that would match that description in the area. And you have no one that places Bryan behind the wheel of the vehicle. So again, another hold in regards.
I think what he's saying is you don't have anyone that places Bryan behind the wheel of the vehicle the night of the homicides. I think that's what he's arguing. But that's what the cell phone pings will be for. The cell phone pings will be for that. Oh, and also they have him driving so that he's trying to argue perhaps that the Elantra that they see on video driving about and his Elantra might be two different Elantras, even though we have him cell phone pinging with the vehicle and then getting out of the vehicle and going into the store, and we have him on video in a store. So there's a lot more to this than we haven't tied him to the vehicle that's seen fleeing the scene of the murders after they're committed. But yes, technically, that tying that vehicle to his vehicle is a circumstantial chain of events. That I can agree with.
So that because you can't verify that he's the one driving the vehicle.
But they don't have to put all of that in the probable cause, though, right? I mean, could they know that?
No, absolutely not. This is just holes that I got from the affidavit of probable cause that the prosecution could clearly clear up.
Yep.
Right, and really, you anticipate it as defense counsel that they're going to have additional evidence to clear this up. The one that's going to be difficult is the cell phone tower pings, though, found to clear up because Bryan's phone was off from approximately, I think it's 2:30 to 4:30 or 4:45. I don't know the exact times. And cell phone tower pings is, we like to call it as defense counsel junk science, not exact.
Your phone knows where you are. And it's likely that they have his phone and can do a full download of his phone. And guess what the apps on your phone are going to do? The apps on your phone are going to tie you to locations even more fulsomely.
Science. The cell phone tower ping is
Juries
that when you send a signal out, it pings off of the tower. When it hits that tower, it creates a radius as to where you could be placed around that tower. Now, this was approximately, as the crow flies, 8 miles away, I believe, and cell phone tower ping information usually is a 20-mile radius.
Not always.
That's how the expert is going to testify. The only way to get around that is if there's GPS evidence. Now, so when he turned his phone on, or right before he turned it off, you're going to have GPS evidence up until the point, likely, of that in a cell phone dump. And then you're going to have GPS location the second it gets turned back on. That's not in the affidavit of probable cause.
Nope.
It's certainly through the
They probably don't have it yet because they don't have
plus pages that'll be generated from a forensic.
They probably don't have it yet because they didn't have his phone, I don't think, till the time they arrested him. I don't want to teach people to crime better. I'm assuming that he still had his phone on him at the time of arrest. So if he did still have his phone on him at the time of arrest and they have it, they will download all of that, and they will not, if they have recovered the phone that he had on him and has been using, and he has not changed phones or dumped the phone or whatever, if he has the phone, then they will probably move on from cell phone pings to GPS locations by the time they go to trial, because they will have more specific information. The GPS pings are good enough for probable cause. Why is he talking defense tactics? Why is he talking any of this? I don't know. I am baffled, which is why it took me forever for the chat to be like, no, his lawyer talked. It's Bryan Entin has it. It's on Twitter. And I'm like, what? That's why it took me so long, because I can't wrap my head around the fact that this is happening. Part 2 or 3.
Review of his cell phone. So certainly it's more evidence that you're going to be looking at. Again, there's a lot of things. It's like I said, it's a little, I'm saying it contradictory, that it's a strong circumstantial, but there's holes. I anticipate those holes to grow smaller.
Yes.
When the prosecution puts their entire case on it and collects all their evidence, but maybe not. I don't know. But there are certainly holes in the case, and the affidavit of probable cause is just the start. We're in the infancy of the case, and I really do pretty much bank on the Commonwealth. Well, I say Commonwealth because it's Pennsylvania, but the prosecution coming up with more evidence.
There we go.
Obviously,
the statement that you released from Kohberger, where he, said that he was innocent, essentially. Did you write the statement with him? I don't know if you can share how that statement came about.
The statement came about Friday night when I talked to him. I to understand, on Friday, from we were closed, we had a half day. So I knew I wanted to plan out sort of the attack of what I wanted to get done. What I know I needed to have get done because of the media exposure I anticipated with the case. I didn't expect it to be like this. I didn't expect it to be more, I've been told by the AOPC, which is court administration, that really more calls than were on Cosby. They were calling about this. So I sort of got a heads
That's interesting.
up of what to expect. So I sat down in my office at 12 noon on Friday, and
This part I'm not as uncomfortable with. I mean, I wouldn't. I mean, but my general opinion as a district attorney was, thank you for reaching out to me. You can call media relations and they will talk to you. I did not want to be answering questions about my case until my cases were done. And even then, I didn't always want to talk about my cases because I didn't want to talk about my cases. So I referred everything in the media to our media relations department. Now, he is choosing to talk to the media. I'm fine with, how did you get this case? What went down? I still wouldn't make those statements. I don't think those are necessarily barred. I think there's questions. Yes, the gag order's in Idaho. This is an attorney in Pennsylvania, but this attorney is connected to the case, but only connected to the Pennsylvania part of the case. I still think there's an issue of what him talking about what he said to Bryan Kohberger and what Bryan Kohberger said back to him. Now, Rob makes a good question. And makes a good point. If the dad is there too, that destroys the absolute privilege. There's another party. This is a conversation that's not just being had between attorney and client. There are more people in the room, but that's not exactly clear to me. And that's part of what's making all of this so uncomfortable for me, because there are questions. I'm so glad to see that Hoeg's GoFundMe is at almost 60K. Thank you for sharing that. That is such good news.
I wanted to plan this out as to what I wanted to get done. Two things that I felt most important is making contact with the Idaho Public Defense Commission, obviously talking to Bryan as soon as possible, getting a statement out based upon my conversation with Bryan, obviously, talking to the family and getting potentially another statement out.
And it seems like those are two conversations.
From noon to approximately 4:30, I took time to search relevant law, Idaho law, in reference what Bryan would expect upon extradition and returning back. So then I went out to the jail at 5 o'clock. I know there was a lot of people, a lot of news media outlet at the jail at that time, but I knew it was dark out, so I could essentially sneak in under the cover of dark and be able to talk to him without anyone knowing that I was actually there. And I spoke to him for about an hour. I let him know about the statement.
This all makes me very uncomfortable.
That I wanted to get a statement out there because
for this part, he went to the jail to talk to him. It's not clear to me that the dad is present at this time. This is too much of a question to make me comfortable. But then again, if it's a gray zone, I'm generally wanting nothing the fuck to do with it. I don't want to be in a gray zone when it comes to the things I can and can't do. I don't want to be anywhere near that at all. I do not. When it comes to, can you talk about this? He is saying that he went to the jail and is having a conversation with Bryan Kohberger. To me, it seems that the default is that shit is privileged. Why the fuck are we hearing about it? Also, I'm a legal commentator and I want to talk about it more, but also, why are we hearing this? This seems like a privileged conversation until we know more.
With all of the news media, I knew there was going to obviously be issues as far as him receiving potentially a fair trial, people jumping to conclusions.
The internet's going to internet.
You worry about the presumption of innocence and the integrity of the criminal justice system. So I said, Bryan, is it okay if we get a statement out?
I'm fine with the defense attorney saying, not even when I met, my concerns in this case and the reason that a statement was put out was because of these concerns and nothing more, because a statement was put out. But I said to my client this, and my client said back to me, this are words you shouldn't hear from a lawyer unless they're standing next to their client at a press conference and the client has waived confidentiality. And the only person that can waive it is the client. And I haven't heard Bryan Kohberger say, my attorney told me this. I haven't heard him waive it explicitly or implicitly in any way. And even if he had, maybe, I still as an attorney would be deeply uncomfortable at the very earliest stages of a very public criminal case saying anything. I don't like this. I don't like this. I don't like this. Julie, this is not a lawyer leak because it's an interview. This is an interview with Bryan Kohberger's prior criminal defense attorney. How is that happening? I don't know right now because Bryan hadn't asked and this guy seemed to say, yep. So this is the extradition criminal defense attorney from Pennsylvania. Could they extend the gag order to this dude? They could go to Pennsylvania. The court in Idaho could ask for that to be initiated in Pennsylvania to have jurisdiction over him. I think best practice is I wouldn't want to run afoul, but that's not every lawyer. There are going to be lawyers that are just like, hey, Idaho, I don't practice in Idaho. That doesn't apply to me. Come get me. I'm not that lawyer. No, I'm not. If the court says, hey, you can't do this, even if you might not have jurisdiction over me, I'm generally going to abide. I'm a rule breaker in some ways, but that's not one of them. So no, I would be on the safer side of this. I don't like this at all. But also I'm a content creator, so let's keep going. I'm just going to keep telling you how uncomfortable all of this makes me, but it's on the internet and we're going to, yikes.
And that's when he brought up the eager to be exonerated language. And obviously that was included in the statement.
So that was him. That was him who wanted to put that in.
The eager to be exonerated was the language he used. We put it in the statement.
The statement should be the only thing that
when
exists.
I talked to him about the eager to be exonerated, To me, when we talked about it, it was more or less he was asserting innocence, but that's the language.
When we talked about it, we shouldn't hear anything about an attorney's conversation with their client. There's a part 3.
Get a fair trial here. Do you think that Kohberger can get a fair trial here in Moscow, Idaho?
There is no way he can get a fair trial in Moscow, Idaho.
That's a definitive statement.
I don't know
if he can't get a fair trial in Moscow, Idaho, where can he get a fair trial? Because the internet exists everywhere.
He can get a fair trial in Idaho.
Oh, he wants
Just
it out of the state.
Because of the attention, you think, or?
Yeah, I mean, obviously, due to all the media news outlets, the attention it has gotten. I mean, you're talking about an international case now.
So where would you like to try the case?
A social media is also an issue here. I mean, this is really
social media. Maybe he's going to blame Bravo editing next.
One of the first cases. I mean, you had the Petito. I think Petito is correct. I'm pronouncing
Petito,
right?
yeah, Gabby Petito, yeah.
There are lots of cases, criminal and otherwise, that capture the attention of a nation.
The Gabby Petito case, I mean, that
Petito
had something like this, but I mean, my
time,
understanding about this case specific, I mean, this has blown up on social media to a point where most people ages of 18 to 25 have actually posted comments on it. So
I challenge that. Challenge. Most people 18 to 25 have posted something about this case on social media. Sir, that is wild speculation. Because, so Dear Sweet Dr. B is not on social media much. And when he is, he's talking about like snakes. Or weather or like punk music from the 80s. He has a very specific amount of things that he looks at on social media, but he hasn't, he's also not in this age demographic, but he has not seen much media on this case. And when I talk about it, he's like, wait, what? And I'm like, do I have to catch you up on what's going on here? Like get on my page. And he's like, I haven't heard much about it. Most people, this is a wild speculation, but to say when you are commenting on things, I wouldn't be surprised if most people in this age range have seen content on this, maybe, but he's saying no, most people have commented on this. Have you taken a poll? Did you ask Bot Sentinel? How do we know? I'm backing that up because I kept talking.
Social media to a point where the Gabby Petito case, I mean, that had something like this, but I mean, my understanding about this case specific, I mean, this has blown up on social media to a point where most people ages of 18 to 25 have actually posted comments on.
Objection, calls for speculation. Did you not watch Depp v. Heard? Where have you been? Objection, calls for speculation.
On it. So I'm not on social media. I don't believe in social.
Then how do you know? Wait, is he saying I don't believe on social media? I'm gonna let this roll and then I'm gonna give all my thoughts at once.
On it. So I'm not on social media. I don't believe in social media. People are too free to express their really views without repercussions.
I said I wasn't gonna. People are too free to talk on social media. People are too free to speak on social media. My guy, I'm sorry, you're a defense attorney. Do you not? The Constitution is like your whole gig. Like the government's not adhering to the amendments, the fourth being a popular one. Presumption of innocence, right to remain silent. Like the Constitution's like your gig, like a whole lot. People are too free to speak on social media. Is that what? Wow. Wow. I mean, I get people wild out. People wild out on the internet. Like I get that, but Vincent Van Gogh has thoughts. I'm not on social media. I don't believe on social media. People are too free to speak without repercussions. We have a whole amendment on that. It talks about the press being free and people being free. You know, I think they put those in order of importance. And so they made that one first. People can be dicks on social media. I mean, let's not mince words here. People can be dicks. But they have the right to be dicks. They can't be defamatory. We've seen that lawsuit in this case already, but holy shit, that just happened. I can't process. We're backing that. Oh my God.
I don't believe in social media. People are too free to express their really views without repercussions, to say. And in this case, a lot of people have already expressed either guilt or innocence. And really neither helps either the prosecution or defense. Because, I mean, listen, at the end of things here, and I want to make this very clear and important.
I want to make this very clear and important, sir. You don't believe in social media. And you think people are too free to talk. I think that you're too free to talk. You're talking about conversations you had with your client for the love of Dave Matthews, sir. You are talking about conversations that you had with your client and are talking about people being too free to talk. You are way too comfortable with this conversation. This is not real life. Have I slipped into a parallel universe? Did the weather do that? What is happening? American Express is so glad we're not talking about them today.
And the family would really make this clear and important. Listen, there's 4 families suffering from loss, right?
Yes.
I mean, they will never get their loved ones back. And they want justice, okay? But we want to make sure
they're entitled to justice. For me, it's beyond a want. Deserve justice, but that's okay. I'm not going to, don't nitpick. He already said that people are too free on social media. We're going to stick to nitpicking on that. We will absolutely have thoughts on that. I have thoughts on that.
everyone wants to make sure that the right guy is the one
I agree.
that they have at trial and the one who ultimately is convicted. Whether that ends up being Bryan or not, I can't say. The evidence will ultimately come out at trial. But the important thing is that he's presumed innocent until proven otherwise.
And just my last question, there's the hearing tomorrow morning, the status hearing, where they'll talk about the possibility of a preliminary hearing. It's my understanding the defense can waive that. Do you think there should be a preliminary hearing? I mean, if this was your case now, is that in his best interest?
Well, I mean, my understanding is it is going to be a status hearing. I had watched the initial arraignment, and I know that his attorney Taylor had requested for a status hearing, but I believe the judge listed it for a preliminary hearing, so I was a little bit confused but I think it's been verified that it is just a status hearing tomorrow. And I absolutely anticipate there to be a very long preliminary hearing at some point, whether that happens tomorrow or in the future. I would anticipate a preliminary hearing based upon the affidavit of probable cause. Okay. And if I circle back just a little bit,
don't circle back.
One thing that I didn't address was the shaky ID by DM in the affidavit of probable.
So do you want to argue this case to social media because you hate social media? Do you want to go back to the shaky ID and the probable cause affidavit? Do you think you're helping? Because this isn't helping me with.
One thing that I didn't address was the shaky ID by DM in the affidavit of probable cause. I would without doubt say that is at best a shaky ID.
Why?
That any defense counsel is going to have a field day with on cross-examination.
Lots of people have bushy eyebrows. Fine. Fine.
What do you mean by shaky ID?
Mine aren't, but mine are great.
Well, first of all, it's not an ID of Bryan Kohberger. It's an ID of a person who has an athletic, non-muscular build, approximately 5'10", with bushy eyebrows.
Right.
Wearing a mask. It's dark. Obviously, likely.
You don't know how dark it is.
Assuming it's dark. We won't know until.
Yes, you're assuming. You're assuming that there aren't lights on in the house, but it's got to be light enough to say that this person is built this way with bushy eyebrows. Also, I have seen people identify people from eyes when people have the bottoms of their face covered pre-panini. Post-panini, I think we've all gotten very good at looking at people's faces with masks on. We've spent years looking at people's faces with masks on. Pre-panini, it wasn't nearly as common to look at people's faces with masks on. Now, it's like, no, we look like eyes are up here, friends.
DM actually testifies. But really, when you think about it, that's the only direct evidence allegedly putting Bryan at the scene, if it's Bryan who's ID'd. So certainly, I can't say that it's a direct evidentiary link.
He definitely
Bryan,
He backed up. I assume it was dark. He definitely backed up.
I think once examination occurs of DM, there's going to be real issues with even using her testimony.
Why? Why are there real issues? There's questions, but I don't think there's real issues with using her testimony. I think that's a gross exaggeration.
Once examination occurs of DM, there's going to be real issues with even using her testimony.
Interesting. Well, thank you.
It's interesting because if I'm the prosecutor, I'm like, fine, I'm not calling DM at preliminary hearing. If all the defense strategy is this is going to be a real problem, good. Y'all will get to see her at trial. But I want to hear him talk about it being dark and this shaky ID one more time. I want to hear the way he backs it up because he seems to go beyond assuming it was dark, and that might be me reading into it because I'm already real fucking annoyed. But I just want to hear what he has to say one more time about it being dark, or him believing it was dark at the time that a suspect was leaving the murder scene.
So certainly, I can't say that it's a direct evidentiary link to Bryan, and I certainly think once cross-examined,
I didn't back up.
Exemplifies athletic, non-muscular build, approximately 5'10" with bushy eyebrows.
Right.
Wearing a mask. It's dark, obviously, likely.
It's dark, obviously. And then he backs it up going, oh, it's likely.
Non-muscular build, approximately 5'10" with bushy eyebrows.
Right.
Wearing a mask. It's dark, obviously, likely. I'm assuming it's dark. We won't know until DM actually testifies.
He backed that up real quick. This might have, look, we might be reading into it. This might have been him assuming. This might have been him not being careful with the way he was saying it. But he said, it's dark, obviously, and then backed it up to probably, it's likely, we won't know until, again, this is why you don't talk to the media about your case when you're going through the case. Because social media is going to be like, did he tell you it was dark? Because you said it's dark, obviously. Or are you like, what he didn't say was, this is 4 o'clock in the morning. I would assume the lights are off in the house. It's probably dark. So now you've got all these questions. That's not what he said. What he said was, it's dark, obviously. Not obvious to me, because this is happening at 4 a.m. when somebody just picked up their DoorDash. I'm not eating my DoorDash in the dark. Are you? No. I end up with food in my lap. Whoopsie doodle is fucking right. I want to hear this one more time. Because he sure says it was dark with his full chest.
Right.
Wearing a mask. It's dark, obviously, likely. I'm assuming it's dark.
It's dark, obviously, probably, likely, I'm assuming. Is that a gaffe? Is that just a misspeak? I don't know.
We won't know until DM actually testifies. But really, when you think about it, that's the only direct evidence allegedly putting Bryan at the scene, if it's Bryan who's ID'd. So certainly, I can't say that it's a direct evidentiary link to Bryan, and I certainly think once examination occurs of DM, there's going to be real issues with even using her testimony.
It's interesting to me that based on the surviving roommate's limited statement that's been released in the probable cause affidavit, he says there's going to be real issues using her testimony. I have a lot more questions about that bold bold assertion about why there are going to be issues using DM's testimony. Bold assertion. That's a bold assertion for me.
Interesting. Well, thank you. That was really helpful.
Yeah. That was illuminating. Oh my God. Oh my God. Okay. What I want to look at real quick is the statement. Thank you, Bryan Entin, for asking the questions that we didn't think could be answered. Bryan Entin's like, you don't ask, you don't get. This is why Bryan Entin's great, and I'm not a reporter, because I would just be like, I would be so tempted to be like, sir, why are you saying all this to me? Have you heard of attorney-client privilege? Could you explain it to me? I would be so uncomfortable. This is why I'm not a reporter. The statement released is what I want to look at. So we are going to KTVB. Bryan Kohberger, the suspect in the murders of 4 University of Idaho students, intends to expedite the extradition process. A statement released Saturday from Kohberger's public defense attorney, Jason LaBarre, says his client is eager to be exonerated and looks forward to resolving these matters as soon as possible and intends to waive extradition. Mr. Kohberger has been accused of very serious crimes, but the American justice system cloaks him in a veil of innocence. Oh, we like our words. He should be presumed innocent until proven otherwise, not tried in the court of public opinion. One should not pass judgment. Well, lecture us on how to not pass judgment more, sir. One should not assume that it's dark when one does not know. One should not pass judgment about the facts of the case unless and until a fair trial in court, at which time all sides may be heard and inferences challenged. Yeah, but even then, even when you get a full fair trial, do you know what the internet still does? The internet still says, I don't agree with that jury. I don't agree with that verdict. That wasn't a fair trial. Everyone's a misogynist. That's what the internet does. So even if there is a full fair trial, it doesn't mean the internet's going to agree, sir. One should not pass judgment, he says, about the facts of the case unless and until a fair trial in court, in which time all sides may be heard and inferences challenged, which is fair. It's an adversarial process. Is there any more statement? No. All right. That's the end of that statement. I think the safe play for this attorney would have been to say, sir, Mr. Entin, I respect your work. Thank you for continuing to talk about this case and reminding the public that there's a presumption of innocence. I would cite you back to my previous statement that was released with the permission of my client. I will be making no further statements. Thank you for your time. I would expect that that's what would have happened. I did not expect that in a case where there is a gag order, we would see the previous defense attorney talking about the statements his client made to him and the statements he made to his client. I said to my client, XYZ is privileged. My client said to me, XYZ, also privileged. I would be curious as to why this attorney thought that this was okay, why he thought this wasn't covered. But when he says I went to the jail and had a conversation with the defendant, it's not clear to me that that's a conversation with the defendant and his dad at the same time. It's clear to me that this defense attorney at some point in time had a conversation with the father, and maybe it's okay to share that ethically. I still wouldn't want to touch it. Feels great to me. Don't want to touch it. Also, I don't want to give the public any more information about this case if I already feel that the public is against the person who I owe a duty to. Other than to say, thank you for reminding everyone there's a presumption of innocence. This is the previous statement. I'll be making no further statements. Instead, he has a whole chitty fucking chat with Bryan Entin. Good for Bryan Entin. Good for all of us on the internet to have more information. But holy fucking shit, how do we think that this is okay? Yes, there is an argument that the Idaho court cannot extend to an attorney in Pennsylvania. However, I tend to give deference when a court has made an order. Even if it doesn't apply to me, it's like, that makes me uncomfortable. But what I give and that would be covering, hey, this is the previous statement I made. Hey, this is what the father said. That's not privileged. But when you get to, I told my client told me, it makes me real uncomfortable. Commenting on the state of the evidence for a case where you still owe a duty to an individual makes me real uncomfortable. Obviously doesn't make this attorney uncomfortable. That's just my opinion. I don't like it. I don't like it. I don't like it. I'm sure every attorney on the internet's going to react to this. So I look forward to seeing what they're going to say. I look forward to seeing what Natalie Lawyer Chick has to say about this. I'll go watch what Lawyer You Know has to say about this. He covered it this morning. He's going to be on WFLA this afternoon. I'm going to get to a few more questions. I have to know how much American Express is being sued for, and then I have to go because I have to eat before I have meetings this afternoon. And then I have something else that I have to do this afternoon. So I need to know how much American Express is being sued for because the loop is still open for me and I need to close it. I also need to acknowledge your super chats. Thank you for the super chats. Acknowledge that if you are new here, please like and subscribe. Emily, please don't stress about this attorney. He's giving great content to discuss with us and I'm loving it. It still makes me really uncomfortable. As lawyer brain is really uncomfortable with that. Content brain is like, I mean, you do you, boo. We're going to chat about it. But I didn't expect that today when I prepped the show. Look, this is why I live stream. Because the chat is like, girl. And I'm like, yes. And the chat gave us Vincent Van Gogh today. Vincent Van Gogh is not pleased with this defense attorney. Code Death Star. It's getting lighter now, so Code Death Star might not be as effective. But yeah, yeah. Do we know he's a real lawyer? Yes, we know he's a real lawyer. Yes, we do. Is this lawyer trying to cause a mistrial? Can't cause a mistrial for a case that hasn't started yet. And there's a lot of information already in the public eye about this case. I think it's really interesting that this attorney chose to say what he said to his client, though. It makes me uncomfortable. What's the difference between prison and jail? Prison houses people post-conviction. Jail houses people pre-conviction. If it was brightly lit and she saw a 5'1" blonde, chubby old guy, would he feel comfortable using her testimony? Probably would be like, see, it's clearly not him. Even if he came to Oklahoma where I live, it wouldn't be a fair trial. Where are you going to go? And that's a big question in the age of the internet. The internet's everywhere. So where do you go? If Pennsylvania attorney had stuck to the affidavit issues, it would still be odd for me, but I wouldn't be as uncomfortable as saying what the client said. If it was just like, yes, I've reviewed the affidavit. This is just my opinion on the affidavit, not a comment on behalf of Bryan Kohberger. This is just my opinion on the affidavit as a defense attorney. But even still, it makes me uncomfortable because he still owes a duty to that client. And so, of course, being the prior defense attorney of Bryan Kohberger, people are going to take it with a lot of weight. It still makes me uncomfortable. But no, it wouldn't be as big of an issue as saying my client said. Yikes. Only with eyewitness testimony, they have DNA at the place of the murder. They aren't going to need to only use eyewitnesses. What is this guy saying? He's making defense arguments, which the defense arguments don't bother me as much. Is he trying to create an ineffective assistance to counsel? He's not the counsel. So your clients normally only have a high school diploma. That's not, I mean, truly, that's not uncommon, but it was interesting talking about how intelligent this defendant struck him as and how educated, which again, those kinds of impressions I don't think help because again, any more information you give to the prosecution, now privilege has been waived. If it comes up like this defendant, if it comes up what this defendant was like post-arrest, could the prosecution try to call this lawyer and be like, well, you told Bryan Entin that he was linear, cogent, intelligent, he understood. That might come up in trial. This attorney might have also just made himself a witness that can be called to the stand. Not the goat, said in Chloe's voice. Not the goat. Can this hurt the case? I don't think it helps. I think the prosecution's their ears are going to perk up and be like, you said what now? And they're probably going to save all of these videos because now this person has seemingly made themselves potentially a witness to the case. Goat, greatest of all time. And Vincent Van Gogh, literal goat. Question, since the death penalty is on the table, doesn't the defense lawyer have to be approved for that? Wouldn't that infer he knows his stuff a little more? The extradition lawyer, I don't know if they would have done a death penalty approved extradition lawyer, though this lawyer did say that he had worked on multiple capital cases. That doesn't necessarily mean death penalty cases, though they can be synonymous. They're not always synonymous, but he did say he'd worked on numerous capital. This is a 17-year attorney. I'm also a 17-year attorney, but this is a 17-year attorney who has a lot of experience, who is a criminal defense attorney, who would have been qualified to handle this level of case, even though it's just for extradition. He's not the trial attorney, so I don't think they would have looked as much. I think we've broke Emily into drawing her attention to this video. You broke my head. I can't believe this is happening. Emily, please refer people to Reality Life with Kate Casey to hear your interview. I did share it on social media. I can link it again here. She always has great questions and needs more recognition. She does always have great questions. She always gets the best guests, not just me. I'm not the best. She gets really great guests and has really interesting questions. So I did share that on Twitter and I shared it on Instagram. I will share it elsewhere. But yes, I was on, I believe it's Friday's episode of the Reality Life with Kate Casey talking about Jen Shaw. Did I talk about this too? I might have. I don't remember. I've talked to a lot of people in the last week. This seems unprofessional, if not unethical. I have questions. Will this trial be televised in some form? We can assume it probably will be. Is this lawyer making any money off of this? The news generally does not pay for interviews. Occasionally the news might pay for use of photos, but the news does not pay for interviews. And he would have been paid minimally for being the extradition appointed attorney. But if he's a public defender, he's salaried. So it's not like he's getting paid more. And even then, if you're a government attorney, you can't even like take a fruit basket. Like you don't take gifts from people. So no, he wouldn't be getting paid for this in any way. Do you think the Pennsylvania bar will sanction him? I think it would have to come to their attention. Somebody would have to complain about it. I don't know. I don't know how their bar works. Why do I get the feeling that he's trying to help someone get away with murder? That's how I feel about a case like this. I don't know. It feels yuck. Will this interview be brought up during jury selection? No, the whole case will be brought up during jury selection, not this specifically. It'll be, have you seen coverage of this case? Have you formed an opinion? Things like that. Advice for a first-year law student from Arizona: set boundaries, set study boundaries. Your brain doesn't work well when you're tired, over-caffeinated, or drunk. All of those things need to be said. Cheetos are not an adequate dinner 90% of the time, but 10% of the time I find it to be acceptable. And don't forget to keep moving. I found that, especially with walking during law school, my brain would make connections to things. You need some quiet downtime for your brain to make connections. You cannot always be actively studying. Sometimes the brain needs passives. Set boundaries around sleep. Sleep. You have to sleep. You will not survive law school if you don't sleep. And if everybody's like, oh my God, I've been pulling 3 hours of sleep for months and months, they're not heroes. They're idiots. Don't listen. The law student who wins is the one who's well slept for exams, because you have to set boundaries. You could study forever and you'll still not know everything. So boundaries. Florida is from Florida. Yes. Thank you so much for explaining all of this to us. I can't explain any of this. Like, you guys are going to be like, how the fuck did this happen? I don't know. What will happen if they don't find the murder weapon? The defense will be like, well, there isn't even a murder weapon. And the DAs will be like, there are knife wounds in people that have been killed. And then there's a giant sheath for a knife. So, yeah, it's circumstantial, but the jury's allowed to make those circumstantial leaps. When you have a sheath and you have knife wounds, you're allowed to be like, it seems like somebody used a knife. So circumstantial evidence is allowed. Not all murders have the murder weapon in court. And yeah. And so, will the defense claim that the crime scene has been contaminated because they were starting to clean up before? The defense might argue that some evidence should keep out if they say it was improperly collected, but oftentimes the defense, the crime scene is completely cleaned up before the defense attorney ever gets the case. So the fact that the defense attorney was able to go to the crime scene before it was completely remediated is rare and beneficial to them. So no, they are supposed to get all of the videos and the interviews and the charts and all the discovery they will get. The only time when you're arguing that the crime scene is tainted, if like people are tromping all through it before it's preserved with video and people marking evidence and things like that. So no, not because they were remediating it. Issues with the crime scene would come up prior to the collection of evidence. This is at the end of collection of evidence, if that makes sense. Sorry, off topic, but I saw the 2023 Lunar New Year's Starbucks mugs. Ooh, I haven't seen those. They're so cute. I'll go look. We love Lunar New Year. Does he think he's at a bar with his buddy? I mean, Bryan Entin feels like the guy you'd be at the bar with having a chat, but I think that probably makes Bryan Entin really, really fucking good at his job, that you feel like you're having a conversation. Isn't he the one being too free? Yes. It's obviously dark. Sounds like he has knowledge. I think the internet's going to assume that. Daryl Brooks, you don't have to prove motive. That's also true. You don't have to prove motive. And they might not. The jury's going to want motive, though. so does society. Like the internet also wants to know, like, why were these students targeted? Why was this house targeted? And why did this happen? People want answers. They're going to want answers in the Murdaugh case too. I talked about that last night on Court TV. They're going to want answers, especially in Murdaugh. Why would someone murder their wife and son? The jury's going to want to know. So all of this, some of the horrifying things that have come out of this case are the photos from the outside of the house with literally blood running outside of that. It's just this crime scene I can viscerally visualize based on all the reporting, and it makes me sad. When does attorney-client privilege end? When the client ends it, or when there's no longer a client. Attorney, you owe a duty to your client. That is privileged until your client waives the privilege or your client passes. And even then some attorneys will be like, no, I'm not talking about it. So that is why you have to be careful of the clients you take. You don't have that choice as a defense attorney. And it's different as a prosecutor because I didn't have clients in that way. When I worked in consulting and when I worked with online businesses, I had clients. But as a DA, you don't have clients. You represent the state and the people. So it's different. Can BK waive privilege to that specific lawyer? He could have. There's no evidence of that, but could that? Yes, it's possible. But if I'm the lawyer, what I'm saying is, hey, Bryan Entin, the only reason I'm speaking about this with you is because it has been approved by my previous client. I am making it so clear because not only is the internet, but this man might not be aware of law Twitter, but I imagine law Twitter is going to have some conversations about this too. I just wouldn't want other lawyers questioning me. I'd want to explain or over-explain as I'm wont to do. Will the attorney explicitly say, don't tell me if you did it or not? It depends on the attorney. I think all attorneys have their own way, and it depends on how you connect with clients. Some clients are going to need to talk, and you're going to be the only person they can talk to, I would imagine. But that's a great question for Natalie Lawyer Chicken Runkle. It depends. And some lawyers might say, it doesn't matter to me whether you did it or not. So you can tell me what you're comfortable telling me, but we're going to need to talk about the things that help me with your case. So if you know this location, you're going to need to tell me about it. If you've never been there, you're going to need to tell me. But what you cannot do is lie to me. And you have to be truthful with your attorney. You have to be. Your attorney can't be caught off guard. If your attorney is caught off guard, they cannot defend you. There's a law Twitter. I would like a few names. Oh no, I don't want to give names. Law Twitter doesn't always get the law right, but there are definitely lots of lawyers that like to discuss things on Twitter. I'm not always a fan. I like LawTube better than I like Law Twitter. LawTube is superior to Law Twitter anyway. But it's also hard to really thoroughly discuss a case in a tweet, to be fair. We get to talk for 3.5 hours. Me on Instagram today. Yeah, we're going to chat. It's not going to be 4 hours like it was on Tuesday. Me at 3.5 hours in. Let's see how much American Express is being sued for. Why is Nancy Grace trending on Twitter? This is why I don't go to Twitter. Oh, because Nancy Grace is literally live reporting from a fold-up table. I can't do this. This is like when people ask me, do you want to be on TV more? I'm like, if I can do it from my house or nearby my house, sure. This does not look fun to me. This does not look fun to me. This does not look fun to me. This might be fun, but not to me. Like this looks cold and difficult and stressful. Nope. I was on Court TV last night in my fuzzy slippers. Nancy Grace might also be in her fuzzy slippers. We don't know. I don't know why she's trending, but apparently she's on site. I was trying to pull up a document. I'm going to swoop. We went to the non-dissemination order. I just need to know. Damn it, there's two things I need to know. Okay, there's two things we need to know about Girardi. We're going to talk about Girardi and then we're going to go. Thank you for super chatting. If we super chat from now on, I don't know if I'll be able to get to it, but I appreciate it. It doesn't look fun at all. It doesn't. I like being here. She's setting up to sign autographs. She does. Even her hair looks cold. It does. I'm not a lawyer, but I play one on Twitter. So many lawyers on Twitter also seem like they're just playing one on Twitter. Glad to catch one live, even if it's a couple hours in. It's always a couple hours in. Excuse me. 12K in the chat, but under 1K likes. Oh yeah, don't forget to like. I think we all just get engrossed, and I forget to ask. I'm not a great streamer when it comes to that. I don't ask to do the likey, subscribey things. I always forget, but the chat always asks for me, so we're all good. Everybody knows everybody knows what we're doing. Okay. Where is my Girardi case? Let's see. I need to know two things. We're shifting topics real quick, chat. I'm not going to make the chat shift topics if you all are still discussing this case because we've moved up real quick, but I've got to switch topics real quick. The bankruptcy trustee in Girardi case, this is the largest legal scandal of literally our time. It is so freaking crazy. When I talked about this on Tuesday, there were 105 new lawsuits going after the money. What do I always say about the money? Put it in the chat. I'll say it in a minute. There are 7 new advisory lawsuits. We are now at 112 lawsuits if I've mathed properly, but I did use my fingers and not a calculator, so maybe not. The bankruptcy trustees special counsel has now also sued Torrey Pines Bank, where money was moving back and forth through for the law firm. Baker, not myself, Baker, Keener, and Nahara, LLP, seems like a law firm because it's LLP. Alt Financial Network Inc., Citizens Business Bank, Comerica Bank, Nano Bank, American Express. Yes, chat. What do we say about the money? We follow the money. This is exactly what the bankruptcy trustee is doing. The bankruptcy trustee is following the money and trying to get it back. In all of these lawsuits that we've looked at, the purpose for the bankruptcy trustee is to say, you were improperly paid within the 7-year period prior to bankruptcy. Give me back the money. We're entitled to it back, and then litigating that. Or people saying, okay, fine, we'll give it back. I don't know if anyone's going to do that. But the bankruptcy trustee through counsel has now sued Erica's son, Erica, Tom Girardi's daughter, Tom Girardi's son-in-law, his fucking high school, his law school that he's given money to. You know who hasn't been sued yet is Governor Gavin Newsom. He had millions donated. I wonder if it was in the 7-year period. Can you get political donations back? I wonder, but they seem to be going in groups. Like there was a group of all aviation stuff, and now we're getting a group of banks. Will we get a group of politicians? Only time will tell if the politicians get sued for political donations that were transfers from the law firm. But then again, is it proper for the law firm to make political donations? Yes. But what I really want to look at is two things. One, we're going to look at how much American Express is being sued for because I'm really curious. And then two, you guys, the auctioneer report is in. I need to know who bought the scandal earrings because there's been some rumbling about that online. Nancy Grace is trending because she set up a table outside the house. Okay. So we've seen it. We've seen the thing. I've been asked about my thumb holes. I generally get them from Target. This one is from Target from a few years ago. And if I found another one, I would buy it in every single color. I have short arms. I love thumb holes because it helps with the fact that I have short arms. So making me not the best water polo player in the world. So let's go. But my kids do fondly call me Mommy T-Rex on occasion to tease me about my short arms. But anyway, thumb holes make it easier, and I find them cozy, and they just make me happy. All right, American Express. Avoidance of recovery, fraudulent transfers, avoidance and recovery of preferential transfers. This is getting paid when the law firm is clearly insolvent. This is saying you shouldn't have gotten paid when the law firm was insolvent, but you did. All of these start the same. Somewhere they're going to reference the Wizard of Oz, and then they're going to talk about what this particular suit is over. These are all the same at the beginning. Excuse me. Let's see. So we're going to get to the part just about this. Plaintiff is informed and believes and bases thereon that the defendant, American Express Travel Related Services, AMEX Travel, is a New York corporation authorized to do business and doing business in the state of California, and informed that American Express Travel is a subsidiary of the American Express Company. At all relevant times, AMX was the initial transferee. Plaintiff is informed and believes and bases on that defendant, American Express National Bank, is a Utah corporation, place of business located. During a time when Girardi case was in a precarious financial state, was not paying its creditors, they began the systematic process of draining available cash. And they're saying some of that went to American Express. I want to know how much. You heard me yell about the American Express accounts on Tuesday. The CFO has 17 different numbers in 7 years. That seems sus. Tom Girardi had 12 or 14, I think. Holy shit, that's a big number. With respect to AMX during a 7-year period prior to the petition date, Girardi Keese made approximately 767 payments to American Express on account of the American Express accounts in the total aggregate amount of, that says $50 million, right? $50 million in 7 years. Here's the thing, though. American Express is going to turn around and be like, it's not our fault we got paid. They're the ones who spent it. They should indemnify them, sue them. And the bankruptcy trustee has. The bankruptcy trustee sued Erica Girardi over American Express payments made and said, you got like $20 million in you charged things onto American Express that were not for the law firm, that were for you. And then the law firm paid $20 million to American Express to pay for you, because it's expensive to be you. So you give us back that money. They sued the CFO and said, you got $22 million in 7 years of personal expenses that were put on the business credit card. So give us back the $22 million. And now the bankruptcy trustee is like, also, there's $50 million here. I mean, I think between Erica but Erica's might not have been within 7 years. I need to go look at that time period. But yes, $22 million was just for the CFO of this. Why is the CFO getting so much money? Like how? Girardi Keese made 767 payments to American Express on account in $50 million in the 7-year period, 515 payments in the 4-year period of $26 million, and 195 payments in the last 2-year period of approximately $8 million. With respect to the fraudulent transfers, no less than the amount of $9 million was on account of purchases that solely benefited Tom, Erica, their family, and friends. So $9 million to Tom and Erica in that 7-year period. They're clawing back further, I think, for that $20 million to Erica. But $22 million in 7 years to the CFO is a fucking wild number. Just wild. With respect to AMEX during the 90-day period prior to the petition, Girardi Keese made transfers of property in the form of approximately 8 payments to AMEX in 90 days for $50,000. Let's go see the attachments, because those are always interesting. And we've already gone through the causes of action and other coverage on Tuesday. Let's see. So these are the American Express payments that they tracked. So this is the 90-day total. This is y'all, I'll let you know when I get to the point that I'm paying a credit card bill at $200,000, because I feel like that's just not my life, and we're never going to have that experience where I'm just like, oh yeah, no, just pay it. Oh no, it's $200,000. That's fine. Just pay it. Just pay the balance. I'm always thrilled when I pay the balance. But the balance is never $200,000 at a time. This is just not my life. And again, operating expenses of a law firm are different. What they're saying is these aren't operating expenses. These were personal expenses. The credit card company is just going to turn around and sue the holders of the cards. Maybe that's the point. So these are all the payments. These are I wonder if these are coming out of different accounts, because this is $200,000 and $6,000 on the same day. This is $60,000, then $50,000, all within a close period of time. I mean, the way money is moving. Look at these. This is February 3rd and February 3rd, $106,000 and $192,000, which are probably on different groupings of accounts. But the amount of money just flowing through here is so freaking wild. Because these are like credit card payments frequently. Like October, here we're at October 3rd, October 7th, October 10th, October 10th, October 10th, October 15th, October 31st, October 31st, November 1st. These are so many credit card payments. Oh my goodness. So this is the 7-year statute of limitations. There's the 2 years, including the 90-day at $8 million. Now I want to know what's the largest amount paid at once. So far, we're in the 200,000 range. Do we have any larger payments than 263? Like, what's the limit that your bank will let you pay to a credit card at once? I mean, is it 200,000? Is it in the 200,000 range? Where is the limit? All of you in the chat are going to be like, Emily.
The limit does not exist. The limit does not exist.
Sorry, we had to have a moment. Now I'm just curious about the biggest payment in one chunk, because this is fucking a lot of money. Let's see. 204, 208. That is the 4-year total. So it looks like we've got 200. Oh, 320. We're at 320. We have 320,000. All right, 320,000. 320 is our new high number. 462. We've got 462. 462 is our new high number. How much will your bank let you pay a credit card at once? $462,000 is our highest so far. There's 360. Nope, we're at 462. I got 462. Are we going to get more? Are we going to get more than 462? I don't know if we're going to get more than 462,000 in one credit card payment. There's a lot of these for 362,000. A lot of money was being paid in 2015. What were y'all doing in 2015? Because these are a lot of 506. We have 506. We have $506,000 of a credit card payment. 506. 506. On January 2nd, 2015, $506,000 paid to American Express. $506,000 going once, $506,000 going twice. Sold. $506,000 is the highest credit card payment made to American Express in 2015. How what the fuck are you putting on your credit card? Cars? Multiple cars? Like, oh no, I'll just charge it here. All of you. Yes, I'm inspired. And I said, hey, pretty baby, let me give you a sign. I'll do anything to make you mine, oh mine. I'll do your bidding and be at your beck and call. Yes, sold. The Grundy County auction. Facts. I didn't know Grundy County was in Tennessee, and I yelped out loud. I do this when I was driving down the road, because in Tennessee, they put your county on your license plate. So it says there's a Coffee County as well. I was thrilled. I was like, we moved to the wrong place. Why didn't we move to Coffee County? Because my license plate I could have gotten a personalized plate that said I like, and then have Coffee County under it. It would be like, I like coffee. I was like, damn it. How did I miss this opportunity? I didn't know Grundy County was in Tennessee. And so I was driving and I saw a license plate that said Grundy. I called friends. I was like, yo, Grundy County's in Tennessee. And they're like, no way. I'm like, yeah. Going once, going twice. I'm sold on the lady in the long black dress. Well, she won my heart. It was no contest. Ruby red lips, blonde hair, blue eyes, and I'm about to bid my heart good. Stop it, Emily. Stop it. You're having a country day. You need to stop. We need to look at these scandal earrings real quick before you have a meeting that you are inevitably going to be a little bit late to. I'm sorry. I imagine that when people have meetings with me on a day that I stream, they look at YouTube first to see if I'm going to be late. Probably. Apologies in advance. This is 232 pages long. We're not going to be able to get to all of it today. You're not shocked by this news, but I'm going to see if we can find out who bought the scandal earrings, because I want to know so badly. Who bought the scandal earrings? Attached as Exhibit 1 is a true and correct copy of the summary auction report prepared by Moran & Connection. Incurred a buyer's premium of $80,000, sales taxes of, that seems low, $766,000, and a bond premium in the amount of $18,000. True and correct copy of detailed auction report. Okay, let's look at the detailed auction report. Wherefore, 360 Asset Advisors and the jeweler request that the trustee be authorized to pay $100,000 for them in the buyer's premium. Hammer price, buyer's premium. I want to see the list of what was sold. Net profit to estate, $256,000. Total distribution, $356,000. Total due to the auctioneer, $100,000. Let's see. $250,000. Ron Richards did, in fact, buy the scandal earrings. Now, his wife put them on Instagram, and I was like, I want to see if it says it in the report. And there it is. There it is in the report that I'm not watermarking with my Twitter handle because I don't fucking care if people share it on the internet. But Ron Richards, sure enough, bought the scandal earrings. His wife put them on social media, taunting Erica Girardi, in my humble opinion, with the, I can see why you fought so hard to keep them. Ron Richards used to be the bankruptcy trustee's special counsel. He quit and or was yeeted from that position, depending on who you believe. His wife posted a photo of her seemingly wearing the earrings. And everybody's like, Ron Richards' wife is wearing the earrings. Ron Richards bought the earrings. He said he was going to wear the earring or buy the earrings. And I said, I want to see what the report says, because anyone can put on a pair of earrings and say that they're anything. I want to see the report that says who bought the scandal earrings. And there it is. Who is Ron Richards? He is an attorney who gets real shady with Erica on social media. They do not have any love lost for one another on social media, and they definitely get into it. But yes, it is S tier level trolling. It is, I think this is a $250,000 troll. I absolutely do. Do they really want the earrings? No. But I want to know, Emily, is that Denise Richards? No, this is a lawyer who was who comments a lot on these cases on Twitter. Oh my goodness. All right, there it is in black and white, y'all. The auctioneer's report says that Ron Richards in fact bought the scandal earrings for $250,000. Okay, and then we see this individual buying these are other items of jewelry that sold all for quite less than $250,000, and who purchased them. So that's what we got. But there we go. That's what I wanted to take a look. It is did he put it on American Express? Probably did. Got to get the points. Revenge, whatever the price. I mean, trolling, whatever the price. The earrings are worth more. So, I mean, you get a good deal when you buy it at auction, plus the social media trolling that can be proffered from it. So that there it is in black and white in the court documents. The post was on Instagram. Hold on. We'll just go to the post on Instagram. I don't want notifications, because it blew up when they were posted on Instagram, because of course it did. I don't know if I can find this quickly enough, but I'll try. Oh, yep. Good job, Emily. Here's the Instagram post from Ron Richards' wife with the earrings. I now see why you fought for these at the Pretty Mess. Added her on Instagram. They are stunning. Should I have Girardi removed? Because we know they do say Girardi on the side. The shade is the shade is S tier. I mean, it just is. It just is. It is. Ron also said he was going to buy the house. Do you think Ron will sell the earrings? No, I think after Erica Girardi dropped a C-bomb on Ron's wife on Twitter, that he will probably keep them, and she will probably wear them in public and continue to troll with the earrings. I think that will probably continue to happen. So there we go. The Instagram post and the auctioneer certificate. So there it is. The answers are in. That's what I wanted to see. I didn't have a chance to look this morning. This just popped up yesterday. I was busy filming, so I didn't see it. Y'all, we've been through a lot today. Hoeg's fundraiser is over $61,000. We went through a whole storm event. The sun is starting to come out again. We went through lawyers getting involved in cases. We've got Ron Richards buying the scandal earrings, and we have Bryan Kohberger's attorney from Pennsylvania talking about their conversations. The messiness today is so fucking real, but sometimes there's facts and fuckery. And today we've hit all of those. Did we confirm if she turned over the real earrings or the stolen ones? The earrings can be, I want to know, and maybe Ron Richards will share in content somewhere, and hopefully does. I want to know what the serial numbers are on those earrings. The diamonds should be etched with serial numbers. Do the serial numbers on those earrings match the serial numbers on the receipt? He's got the earrings. Go do your own investigation. I've got questions. Mind you, Ron Richards is also suing Erica Girardi on behalf of clients, 2 clients to be in fact. So Ron Richards has pending lawsuits against Erica Girardi, and also has her earrings. I want to know if the serial numbers match. Hopefully he'll take a look. This is a lot. This is a whole lot. He said he put a bid on the Pasadena home. He did. He didn't buy it, but he did get the earrings. So y'all. All right. Let's keep this GoFundMe going. I also need to thank today's sponsor, 2 Dots. Don't forget to go check out 2 Dots. The link is down below. Download it for free. It is a very, very fun game. It is free to play. It's a game that I appreciate because I've never felt like I had to in-game purchase to enjoy the game. There are some games where you download them for free, and if you don't in-game purchase stuff, you can't enjoy the game. This is not one of them. I find this game very enjoyable, and I have never spent a dime on it, though I am want to spend money on games. I've really enjoyed the free experience. I think it's great. So thank you, and it lets the sponsors know that you appreciate them, and then they appreciate me, and then we can just keep on doing what we're doing. And I appreciate you for being here. Thank you for being you. Thank you for being a law nerd. Here we go. 4-hour streams. Don't get used to it. No, I shouldn't say that. Because we're going to be streaming the Murdaugh trial. We've got a lot for you next week. I will probably do some shorts and reels. If you are not subscribed to Quick Bits, go and subscribe over there. We will have more coming on Quick Bits as I summarize things at the end of each week. It is my goal to have the first episode of Quick Bits out for you tomorrow. I'll share that around social at the Emily D. Baker. Your law nerds, you know where to find me. Do the YouTubey things. Thank you for being here. 2023 is just yeah, it's coming in hot and it's unexpected. Bye, y'all. Don't forget to connect with me on social media at the Emily D. Baker. You can find all our incredible law nerd goodies at lawnerdshop.com. And don't forget to check out The Emily Show and The Emily Show Quick Bits on your favorite podcast player. Thank you for being here. Thank you for being a law nerd. And I will see you in the next one.